CCJ Application AL of 2006 between Brent, Griffith and Guyana Revenue Authority and the Attorney General of Guyana.
Yes.
May it please your honors. May I rise to state, my name is Benjamin Gibson, attorney at law and legal practice in the state of Guyana. I'm accompanied by my disability in 3 years student out of the West Indian train jurisdiction.
May it please your honors, I appear on behalf of the first named respondent, the Guyana Revenue Authority, and my name is Ashish Raj.
May it please your honors, I appear for the second named respondent, the Honorable Attorney General of Guyana, and my name is Mohabir Anil Nandlav.
Well, Counsel, we welcome you. You have the distinction of being the first to appear from your country before this, your final Court of Appeal. And we are happy that you are here, and we hope that we will see you again from time to time. Let us proceed to deal with the matter in hand. Mr. Gibson, you for the applicant?
The applicant, your honor.
Yes. You go ahead.
Before I proceed to address your honors, I wish to state that as I stand here, I consider this a third emancipation for people from this region. The first being 1834, the second being 1966, and this third one being 2004. For us in Guyana, appearing before you is like Christopher Columbus crossing the ocean. It's an uncharted sea. I hope I'll be able to make it as smooth as possible for those who are going to come after me. Your honors, the application before you is for special leave to appeal from a decision of the Guyana Court of Appeal, which was handed down on the 8th day of December of the year 2005. The case itself was heard on the 6th day of June 2005. Your honors, when the decision was given, no application was made to the Court of Appeal for leave to appear before this body. It was not until some time afterwards that we in Guyana understood that this court was actively working and admitting appeals from my territory for adjudication. We accepted this challenge in January of 2006, and at the date that this application was made, more than 30 days had elapsed since the handing down of the decision by the Guyana Court of Appeal. On the 16th day of January 2006, an application for special leave was made to the registrar of this court. that application being within the period of 42 days, within which an application for special leave could be made to this court. Your Honors, in the document dated the 16th of January 2006, four grounds were stated why we sought to invoke the jurisdiction of this court. It was later brought to our attention that what was stated there was not so much the reason for the invocation of the court, but was urging why the application should be accepted. Your Honors, we therefore sought leave of the registrar to file a document which is headed and is now before Your Honors as submissions in reply. And I'm asking this court, Your Honors, your leave to abandon the four grounds which were set out in the document of the 16th of January 2006 and to rely on the document filed with the registrar and headed submissions in reply.
Well, Mr. Thompson,
Gibson, Your Honors.
Sorry, Mr. Gibson, I beg your pardon. The submissions are different in their character from the document which is the application. The submissions contain the arguments in support of the application, but the notice of application contains the grounds of it, so that it isn't really possible to replace the notice with submissions. You can amend your notice, and you can alter or withdraw or change your submissions, but you can't substitute one by the other. You follow me?
Yes, Your Honor. May I say with respect, Your Honors, the application is ready to amend.
Well, perhaps we can deal with the amendment, to if and when it becomes necessary at a little later stage. But there are some basic facts which I would like us to agree on, and one has to do with the date on which the Caribbean Court of Justice Act came into force in Guyana, because in your original submissions, you had put that date as the 1st of January 2006. But I have a copy of an order made by the Minister, by the Attorney General, which fixes the 1st of April 2005 as the date for the coming into force of that act.
Your Honor, I may say, and I agree with you, Your Honor, the act came into effect in Guyana in November 2004, Your Honor.
November. I think it's the 1st of April 2005.
Your Honors,
You have a copy of it? I can
yes, Your
show you
Honor.
a copy if you like.
The Act came into effect on the 30th of November 2004.
No. Could you pass it
The
to
Act.
council
The
for
Act.
me?
I think
You have a copy of it? Pass it to council.
you're differentiating between the Act,
And the rules.
Act
And the rules.
date when it came into operation.
Yes, Your Honor.
The Act itself came into operation, I agree, in 2004.
2004, the 30th November.
The order made by the Attorney General when it should take effect was from the 1st of April 2005.
2005, yes, Your Honor.
Oh, I'm sure with the Act came into force. 1st of April 2005.
This is the Act itself.
Yeah, but when it was passed.
It came into
But it didn't come into force. It was to come into force when it was ordered to come into force.
So it was a sensitive.
But it didn't come into force.
So it had an order. Yes, I agree. There's two different things. The order and the separate order.
Would you show, have you seen the copy of the order? Would you look at it, please?
Yes, Your Honor.
Is that right?
This is correct.
Yes. And the Act provides, I think in Section 3, is it, that
The Act, yes, Your Honor.
provides for the agreement establishing the court and the rules made under it to be part of the law of Guyana, does it not? Do you have a copy of the Act?
Yes, I have a copy of the Act with me.
Section 3, perhaps you could read Section 3 for us.
Section 3. The agreement and the rules of court made thereunder shall have the force of law.
Yes. And, yes, so at the time when the judgment of the Court of Appeal was given, the Act and the agreement, rather, and the rules made by myself and the judges in relation to the appellate function of the court were incorporated in the law of Guyana.
It was, Your Honor, if I may say so. The only difficulty being that there were two sets of rules operating in Guyana. Two sets of rules.
Yes. The other set being
The rules of 2004,
yes.
which we all had. Unfortunately, I was given a copy of the new rules only a week ago. But, Your Honor, as set out in my application of the 16th of January 2006, I seek to abandon those rules and amend and rely on the amendment which I am now asking this court to admit, saying in fact that the court did saying in fact that there was jurisdiction in the court, but because of an omission, we were at that time, and
Because of what?
an omission. We were not alert enough. We did not know. We didn't take into account that, in fact, the jurisdiction of the court had been brought into effect with the coming into force of the order made by the Attorney General, by the Minister. So we in fact stated that the decision was in fact final on that date, but it was not. So we are now asking the court to accept an amendment.
You know, Mr. Gibson, we are very sympathetic to the position of persons that, in Guyana, lawyers in particular, who may not have been kept abreast of the various steps.
Which is correct, Your Honor. Which is correct.
Which these changes were effected. But there is an old Latin motto which you may have come across. It goes vigilantibus lex subcurrit.
Yes, Your Honor. I'm aware of that Latin phrase.
You are old enough like me.
Yes, Your Honor.
To know a little Latin.
So Your Honor,
law helps those
who help themselves, those who are vigilant, those who do not sleep. And I'm sorry, Your Honor.
And that is our problem, as I see it, Mr. Gibson, and yours in particular. How do you get around the fact that you have not really done what the rules require you to do?
I did not.
Would have been to apply within 30 days
To the lower court.
to the Court of Appeals for leave.
Yes, Your Honor.
Now, and I hope you don't mind if I cut to the chase and, direct your attention to what I see, strikes me as being the core of your problem. And it is that while I assume that the court, this court, might be willing to give special leave to appeal, even in cases where that leave might have been obtained from the Court of Appeal, and whether because the Court of Appeal had refused it, or simply for some reason the application was not made.
The application was not made, Your Honors, but something got...
just finished.
Oh, yes, sorry, sir.
I'm saying that this court might, I assume, be persuaded to give a special leave, even if leave might have been obtained from the Court of Appeal. But we are limited by section, is it 8 or 9? 8, which seems to limit our power to give special leave to civil and criminal cases.
Yes, Your Honor.
Not so?
Yes, Your Honor. Your Honor, but if this...
Is this one of those?
I would have had to come to this court in any case, for the reason that we were seeking leave to appeal in former powers, which the lower court cannot give.
Let us deal first with the question of leave to appeal.
Yeah. Your Honor, we had a singular impediment.
I wanted to get from you whether you accept that this is not a civil case.
This may I put it this way, Your Honor? Having regard to the statute, I would wish to submit that this case falls under Section 6B. That is a case where we are we will be approaching the court for redress under the Constitution.
Yeah.
6D.
Yeah.
6D. In any proceedings that are concerned with the exercise of the jurisdiction conferred upon the High Court relating to redress for the contravention of the provisions of the Constitution, for the protection of fundamental rights, and in respect of any other matter as may be prescribed by law. And my submission at this stage is that this application is in connection with the protection of fundamental rights.
Yes.
Because as we see it, the Constitution is divided into two parts, constitutional rights and fundamental rights. And this is a case involving fundamental rights. So,
In what regard may I ask, Mr. Bishop?
in two regards. A, in relation to the superannuation benefits and other rights, including salary. The application to this court is based on what is called a violation of Section 6 of the Guyana Revenue Authority Act, which gives to every employee the rights that they had when they were public officers. That is to say, they got their rights under Article 142, protection of their salary, and their rights under Article 149D, protecting all superannuation benefits. Article 149 149B of the Constitution of Guyana, which is a fundamental rights section, said every public sector worker shall enjoy an absolute and enforceable right to any pension or gratuity granted to him or her under the provisions of any law or collective agreement of any kind whatsoever. And this is a case which falls squarely within that section. I have provided the court with the Constitution of Guyana, and I think that is on page 98 of the Constitution.
But if I think we can assume, I don't know, I don't think that it is in dispute really, I think it is accepted by the respondents that this is a case that falls within that paragraph D as you submitted. Now on that footing, you would have been entitled to appeal as of right.
As of right to this court.
Yeah, but under section, I think, under part 10.2
10.2
of the rules of the CCJ, would have had to nonetheless get leave of the Court of Appeal. And on that application, one thing, the matter of security, of course, would have been dealt with, and possibly, although I didn't understand your submission on this, the question of appealing as a foreperson. But leaving aside the second thing, the second aspect for the time being, you not having done that, can it be cured by applying to us for a special leave? If the case is not a civil one, are our hands not tied by the restrictions, the restriction in Section 8 to criminal and civil matters.
May I put it this way, Your Honors? Your reference to 10.2, which I've heard and I've read, and 10.2 says, no notice of appeal shall be filed, A, unless leave to appeal to the court has been granted by the court below, in cases in which there is an appeal as of right to the court.
Yes.
And 10.3 says, provides that an application for leave to appeal in accordance with 10.2 shall be made within 30 days of the judgment being appealed against.
Yes, I'm sorry. That last bit I missed. Would you repeat what you just said?
Just referring to Your Honor's reference to 10.2.
Yes.
10.2 says, no notice of appeal shall be filed unless A, leave to appeal to the court has been granted by the court below in cases in which there is an appeal as of right to the court.
Yes.
And 10.3.1 says, provides that an application for leave to appeal in accordance with 10.2 shall be within 30 days of the judgment. But then 10.4 reads, however, this court, it is open to this court to appeal for special leave, since application to this court must be made within 42 days.
Yes.
An application for special leave to appeal may be made to the court in writing within 42 days of the date of the judgment from which special leave to appeal is sought, or in cases in which leave to appeal is refused by the court below within 21 days. So there are two positions. If you apply to leave to the court below and it is refused, you have 21 daes. But we have 42 days in which to come to this court for special leave.
Yes, well, that doesn't apply in this case. There was no application
to the lower court.
To the Court of Appeal, and therefore no refusal.
There was no refusal from that court. There was.
Just a minute. Let's see. You see, would should your course not have been to apply under Rule 5.3 for an extension of time for applying for leave? In other words, ought you not to have made an application to the Court of Appeal, which sought, firstly, an extension of time for applying, and secondly, leave to appeal?
That was one road open to us, Your Honors.
Well,
but
wasn't the only one?
What we contended was that court cannot give you leave to appeal in form of papyrus, which we needed.
Well, why do you say that?
It seems that 10.3, if you're coming in form of papyrus, 10.5, no? 10.5.
Yeah.
The application for special leave to appeal shall state so, and 10.6 is an applicant who seeks special leave to appeal the first person shall file together with his application an affidavit saying so.
It is a person who applies for a special leave.
May be made to court in writing.
A person who applied for special leave to appeal in forma pauperis. At first blush, I don't see why that application could not be made to the Court of Appeal, as well as the application for leave to appeal simpliciter. You follow?
Yeah. Your Honor, my understanding of the rules is that in for pauperis to this court, that power is vested only in this court, not in the lower court.
But why do you say that?
One minute. Your Honors, if I may say, my judge instructs me that the Court of Appeal in Guyana's rule that they cannot grant leave to appeal in forma pauperis to this court. They can only grant leave in forma pauperis to that court.
Well, in what case did they so rule?
It was in the case of Thomas versus the Attorney General of Guyana, and the ruling was on the 16th of March, 1906. 1906. I'm sorry, Your Honor. 2006.
In what month is that?
Thomas and the Attorney General of Guyana.
First time
The State and the Attorney General. The State and the Attorney General.
Are there any rules governing, well, you said in forma pauperis as well as leave to appeal? Any rules of the Court of Appeal of Guyana?
No, Your Honor. Only to that court. And they have ruled in that case, which I know, that they can only grant in forma pauperis to that court, not to this court.
Given reasons.
Now, do you have rules generally about getting leave to come to this court?
No, Your Honor. No leave. No rule has been made. No rule has been made.
But you say that the judgment was on the 16th of March.
16th of March.
As yesterday.
No, not the 16th. That's last week, Your Honor. 16th.
Yeah, today is the
17th. When was that?
17th. Yesterday.
Oh, please, Your Honor, I think I have the decision here. The application, it was done on the 9th of March. The 9th of March. Thomas in the State and the Attorney General.
And,
Von Thomas, the 9th of March.
were reasons given?
No, we ain't got the reasons yet. No reason have been given as yet, Your Honor. And that's one of the reasons, Your Honor, which has militated against this application coming for special leave. The decision of the Guyana Court of Appeal, delivered orally on the 8th of December, was not available to us until the 16th of February.
Well,
So we didn't have the full sum total of what we were really conveying to you.
and you knew what the decision was.
I knew that we had lost.
Did they not, when they announced the decision, did they not get something orally
But they just
by way of reasons?
They just refused the application and promised to put their reasons in writing.
Yes,
They didn't meet until February.
Even so, you could have nonetheless applied for leave to appeal.
That is so, Your Honor. That is so. I could have.
Filed an appeal with, a very broadly worded ground, and indicating that that further grounds would be added when the judgment became available.
When the judgment became available, Your Honor, we for the first time we were seeing that they were trying to reintroduce in the state of Guyana the doctrine of dismissal at pleasure.
Or what?
Dismissal at pleasure. It's being reintroduced. That's what has happened in this case. That's why we were insisting that we were coming.
Well, all the more reason why you could have taken steps as soon as the decision was announced. But
Good night.
I don't know. I mean, what we, I'm sure, would be interested to read the reasons of the Court of Appeal with regard to the ruling that you just mentioned. But in any case, even assuming that even assuming that decision is correct, then that doesn't alter the fact that the application for leave to appeal simpliciter must be made to them. Although the applicant now would run into some difficulty if he was wishing to avoid having to give security for costs and all of that. But at any rate, whatever may be the position with regard to appealing as a poor person, and obviously it would be certainly be more convenient, to say the least, if that application could be dealt with at the same time as the application for leave to appeal. But what is clear is that when you have an appeal as of right, your application for leave to appeal must be made to the Court of Appeal. Now, if it is a civil matter, and you were in those circumstances of the judgment given by the Court of Appeal in Guyana, you were to apply for special leave to this court, then we would have to consider, I wouldn't like to commit the court, but at least the court would not be constrained by the restriction to civil and criminal matters. But unfortunately, in this case, we are under that constraint, and this matter doesn't appear to fall into the category of a civil matter, does it?
It is a fundamental rights matter.
Yeah, not a civil matter.
It's a matter involving the fundamental rights of the citizen. The constitutional fundamental. This is a fundamental right matter.
But you don't ask.
Please, Your Honor. Please, Your Honor.
It's not a civil matter, is it?
The matter before this court here, it is, if I may say, Your Honor, it's a civil matter.
It is? Well, I would have to hear you on that. That is not a matter which has been addressed in your written argument.
It is handled under the civil rules, but really it's a fundamental right matter. Fundamental rights. Not a tort, it's not a breach of contract, it's a fundamental right.
But Mr. Dickinson,
Your Honor.
You know, the Act, the CCJ Act, it has those, 3 sections.
The CCJ Act, sir.
Referred to. And the term civil appears in a number of places in those sections. Civil cases.
Civil cases.
Matter. And there is also reference to criminal
And criminal, yeah, civil criminal.
And then there is a reference to in D, to the type of case into which this one falls, right, where it involves the protection of rights under the Constitution. Not so?
Yes, Your Honor. It does involve the protection of rights.
My understanding is that cases of that kind are not considered to be within the category of civil cases. It may be called constitutional cases, but not civil.
Yeah.
Am I right?
Yes, Your Honor, I would agree with you. I would endorse what you said. It's a different section, different type, different wrong.
So, I am sorry to cut across you like this, but I keep coming back to this rather difficult point. How can we give special leave in a matter which is neither civil nor criminal?
If I may say, Your Honor, that falls within the special discretion of the court. Any proceedings that are concerned with the jurisdiction conferred upon the High Court again to address the confidence and the provisions of the Constitution of protection of the fundamental rights. Any civil or criminal proceedings in the field of the court.
Could you just hold this one?
Oh.
Look at two. The one you referred me to of the rules 1.42. so that what we really circumventing the rules rather than the act. Mr. Gibson, one thing which is in your favor is that this is a case in which the applicant did have or does have an appeal as of right, and a right of appeal under the Act, and what is really blocking your way is not anything really so much in the Act as what is in the rules. It is that 10.2, which provides that there should be no appeal filed without leave, even when there is an appeal as of right. And we would also draw your attention and that of the other council to Rule 1.4.
Rule 1.4.
Which you would see is a general provision.
I have observed that provision, Rule 1.4.
Sorry?
I observed that provision as application of the rules. Any matter within the appellate jurisdiction of the court.
That's not the one.
There's nothing in these rules.
What rule? What number is it?
Sub-rule 2. Nothing in these rules shall limit or otherwise affect the inherent power of the court to make such orders as may be necessary to meet the ends of justice or to prevent the abuse of the process of the court.
Does that help you?
Yes, Your Honors.
That's all right. Don't mention it. Of course, there is another limb, I think, to the second respondent's submission, which is that you have no case. So,
Your Honor, I do not think that was a serious submission on the part of my colleagues.
Well, it seems serious enough.
I would think, Mr. Gibson, you'll have to convince us that your appeal has prospects of success.
Yes, Your Honor, I think I can so do. You want me to submit it? You want to get it? Not yet? Your Honors, if I may say with respect, I submitted to this court with my submissions a copy of the relevant laws of the state of Guyana, which laws are which the Court of Appeal found itself in serious conflict with, and which they determined in favor of the respondent. I would wish, Your Honors, if that the Revenue Authority Act, which has been included in the bundle of documents submitted, and maybe with this court, the act being the Revenue Authority Act, 7904 of the laws of Guyana, with particular reference to one section, section 6. And it is attached to the written submissions which I made.
May I ask you one or two questions, Mr. Gibson? Does your case depend on the applicant having been or being a public officer or an officer in the public service?
He was in the public service, and by statutory assignment, he was taken over to the Revenue Authority. By a statutory assignment.
At the time of his termination, he wasn't in the public service.
He was in the service of the Guyana Revenue Authority. And yeah.
You're not answering me.
Yes, if I may say with respect, sir. He was in the service of the Guyana Revenue Authority when they sent him off.
But was he in the public service?
He was not in the public service as such, but he had those rights, Your Honor. Section 6 of the Act says clearly, and this has been the bone of the contention, and this is the argument. Yeah. Before the appointed date, the government shall notify such of the employees of the department as it wishes to retain for the purpose of transfer to the authority, and such employees shall be engaged on terms and conditions in relation to the remoluments as may be agreed upon between the authority and the persons who employ, and which taken as a whole, not partly as a whole, on a non-exhaustive term, are no less favorable than those applicable to him immediately before that date. That is to say, there is a continuity. And shall, in respect of any person so employed, be a successor of the government with regard to his leave, his superannuation rights, and benefits, whether accrued, that's where he has them, earned, inchoate or contingent. Our respectful submission that if that position is true, then in terms of his previous position, that is, as when he was in a public service, then he could not have been expelled or put out of the service of the authority unless they had complied with the conditions, because his law is no less favorable as a whole, not partly, Your Honors, as a whole.
Yes, but how does that affect the remedies available to him for wrongful dismissal?
Yes, Your Honors, because in terms of the conditions of service which he had, the rules to which he been entitled would be as follows. Rule 64.
Surely,
the employment of an officer shall not be terminated by dismissal for unsatisfactory performance of duty unless the permanent secretary or head of the department had given instructions to that officer as to how he should perform his duties in the written warning.
But just hold up a minute. Surely the provision which you read with regard to the terms of the service,
yes, Your Honor,
that had the effect of providing for the terms of his employment, but does not surely make applicable to him the regulations which are applicable to public officers.
Yes, Your Honor. I'm saying it did for the simple reason. If
you know, I mean, and surely it was what you just read talks about the permanent secretary and the department and so on.
Those were the rights that...
None of which has any application in the context of the revenue.
Those were the rights which he had before. In other words, they had to hear him before they put him off. And I am saying with respect, if those conditions taken as a whole, or to apply to him again, he couldn't be sent off. Because what would have happened was this. Here you're taking a man from a high status. You're transferring him by statute to another status and then dropping him down low. In other words, there would be a forfeiture of his rights. He would have lost it. His status.
Why would he have lost it?
Because
if he was wrongfully dismissed, would he not have at least the right to recover damages for wrongful dismissal?
Yes, Your Honor. May I put it this way, Your Honor? Put it this way. The submission is the conditions under which he was moved, from which he moved, was underpinned to his new position. His new position was underpinned. And if he was underpinned, then he has public law rights. He could pursue those rights as if he were a public officer.
Did he continue to be a public officer when he was removed and placed in the Revenue Authority?
He went to the corporate authority. So he did not continue to have the status of a public officer. What he had was the rights. Yeah. These rights were underpinned. In other words, his new status was underpinned by what he had before. Yeah, in other words, there was no forfeiture.
I know, which meant he didn't lose his superannuation benefits.
He didn't lose them.
No, yes.
And guaranteed by Article 149.
Therefore, if he were dismissed or whatever wrongfully, it means that those benefits he could be compensated for as damages.
No, Your Honor, no, sir, not as easy as that. I thought so too. Because the laws of Guyana, in terms of the Pensions Act, every corporate officer, let me get it please, every corporate officer is as if he's a member of the public service. In 1983, the law was passed.
What are you referring to?
I'm referring to the Pensions Act of Guyana, the amendment. I'm sorry, our copies were sent to the court, Your Honor, with the amended section. They were sent. Six copies were sent, and there was included was a copy of the amendment. Shall be public service. So you can enforce it.
Just to be. Is it this?
Ah, sure.
So you see, your copy is very indecipherable.
What's the title? The Pensions Act?
The termination of service under the Pensions Act.
Oh, the termination of service.
And it says that in the exercise of the powers conferred upon me by paragraph G, public service and service in section 2 of the Pensions Act, chapter 22, I hereby determine that the service of an officer in a substantive appointment with a corporation within the meaning of the Public Corporations Act, including the service, if any, of that officer, in respect of whose superannuation rights or benefits the corporation's successor, shall be public service for the purpose of the Pensions Act. And this notice shall apply to an officer of any such company or corporation who is appointed to the pensionable office. So what I am respectfully submitting is that as long as he has come over, and the section 6 says his pension, superannuation, so on comes with him, for purposes of his service, that his service is service as if he were in the public service. That's to say, he could enforce it as a public officer could have enforced his.
Mr.
Gibson, sir.
Gibson?
Yes, Your Honor.
There had to be a special provision made in relation to pension to provide that in relation to pension rights, the person transferred should be treated as though he were still in the public service.
Yes, Your Honor.
Yeah, but there is also, you referred to a provision which, to my mind, deals with the substance of the benefits to which the person is entitled, the remuneration package and the different perquisites and so on which he is entitled are preserved. But I don't understand that to mean that all the procedural rules which govern the relationship between a public officer and his employer are also transferred.
Your Honor, if I may say, the government of Guyana did not leave it there. They put it in the Constitution, 1.9b. Every public sector worker shall enjoy an absolute and enforceable right to any pension, gratuity, or gratuity or under his service. In other words, it's a fundamental right.
Deals with pension, and that is a separate matter. But that has nothing to do with the way in which he can challenge his dismissal.
If I may say with respect, our Fundamental Rights and Practice and Procedure Act, the Fundamental Rights and Practice and Procedure Act of Guyana, which is that's the submission. Okay. I have it here. Fundamental Rights and Practice and Procedure Act of Guyana, Act of 1988. An application to the High Court for redress under Article 152 of the Constitution may be made either by way of a relating summons or by way of writ of summons. And Article 152 of our Constitution says, without prejudice to any other action with respect to the same matter, which is lawfully available, that person or association of other person may apply to the High Court for redress. So I am respectfully submitting, since it is protected by Article 153, the applicant was free to approach the High Court for redress.
Is there not a judicial review in Guyana?
There is no judicial review in Guyana, sir.
No judicial?
No judicial review in Guyana, no judicial review. It's regrettable. We have the prerogative writs, but we don't judicial review as such.
Well,
No act.
but judicial review is simply a prerogative writs in modern dress.
Maybe even a little bit more. In better garb and modern dress.
Well, but so you have the prerogative writs.
The prerogative writs are up, always been there. We had them since 1893.
If a public officer is dismissed wrongfully, let us assume without being given a hearing and in breach of the regulations, what is the appropriate remedy?
I am saying in this case the appropriate remedy is either forgive me please, Your Honor. The appropriate remedy is either redress or reinstatement.
What do you mean redress?
Redress means compensation of what is lost.
What is his form of action?
The form of action could be either by way of notice of motion or by way of writ of summons.
Oh, dear me. What is his claim? What is it wrong? Is it uncommon law?
His claim is for compensation for what he has lost, because if he has lost his...
What I'm trying to find out is that there are different, as far as I know, different alternatives. He could surely challenge by way of a prerogative writ the decision to dismiss him, which I would have thought was the obvious one.
Or he could come by way of for a declaration.
Or he could come by way of an action for a declaration.
For a declaration.
But I wouldn't have thought that there would be any justification for him coming for relief under the Constitution.
The reason being, Your Honors, the pension is protected under the Constitution. The Constitution protects the pension. Article 214 of our Constitution says, where any portion has a discretion, that discretion must be exercised in favor of, where under any law, any portion of authority has a discretion to decide whether or not any benefits to which this article applies shall be granted. To withhold, reduce an amount, or suspending such benefits, those benefits shall be granted and may not be withheld, reduced in amount, or suspended. And to get those benefits, you can come either by writ of summons, or by action by way of a declaration, or for compensation, or for reinstatement.
Well, tell me, Mr. Gibson, is his claim that his only claim is for the benefits that he would got, or was he challenging the...
He was challenging the removal.
The dismissal.
He was challenging the dismissal, and if at whatever flows from it. That's to say, if I've been wrongly put out, then I must be compensated for the time that I've lost and the money that I've lost.
Well, what precluded him from bringing an action for wrongful dismissal?
Well, put it this way, Your Honors. Without prejudice to what is lawfully available. The reason being this. In the case of RV East Berkshire, let me get East Berkshire. In our book of authorities, it's page 131. 121, Your Honors. At page 123 and 124, but I'm going to read particularly from page 124, letter F, where it says, Parliament can underpin the position of the public authority employees by directly restricting the freedom of the public authority to dismiss him. Thus giving the employee public law rights and at least making him a potential candidate for administrative law remedies. So I am saying in this case, as I advocated some time before, that the position of this officer was underpinned because he was working on conditions no less favorable than that immediately before he joined. He was underpinned.
But it seems to me, Mr. Gibson, that assuming there is merit in your complaints about the dismissal, that you would have had a cause of action for a prerogative order to quash the decision to dismiss, or you might have had simply an action for a declaration that the dismissal was void. Those are what I understand by the term administrative redress, or whatever the word that was used in that judgment. Administrative action, remedy. But that is something quite distinct from a constitutional remedy. And the question must arise whether, even if you are able to bring the case within the framework of a constitutional violation, and to do so would not be an abuse of process.
Your Honor, if I may say with respect, when the learned judges in the House of Lords used public law rights, he became a candidate of the public law rights. I am respectfully submitting, having regard to Articles 142 of our Constitution and Article 149B of our Constitution. Those were public law rights to which he was entitled. In other words, he could have invoked the right to have a declaration that he was entitled to be protected as if he was still a public officer, as in the instant case. Because what he was saying is this: you have all the rights now, as you had immediately before you joined this new service.
Well, it doesn't quite say that, Mr. Gibson, does it?
Your Honor, that's how I understand it. I am listening to Your Honor.
How does it, doesn't it say that you would have such terms and conditions as may be agreed upon?
As a whole, as it may be agreed upon.
Yes,
but
that those terms agreed upon should not be less favorable than the terms which he had already.
Yes, Your Honor. But may I put it this way?
I don't understand that as importing the statute and sort of grafting it on to the terms and conditions actually agreed on.
Yeah, Your Honor.
But it's a benchmark.
It's a benchmark. Thank you very much, Your Honor. That's a very nice note. May I put it this way, Your Honor? How I see it is this. I see that was seen in Price versus Sunderland Corporation. The statute is a contract. There's nothing else. The statute is a contract. What the statute says, that is what to which you're entitled. You have nothing more, nothing less. And nobody can go outside the statute. The Attorney General versus Sutling, the same thing.
What did he have? I mean, what was agreed upon?
Put it this way, Your Honors. What was agreed upon is exactly what is in the book. In other words, the rights were public law rights.
When he became a member, an employee of the authority.
Yes, Your Honor.
When he became an employee of the Guyana Revenue Authority,
yes, Your Honor.
One presumes that there would have been new terms, and in agreeing those terms, the employer will see, well, look, I have to at least keep it at this level because that is what he had before, or I may want to improve on that. But what actually was agreed on?
Just one minute, Your Honor. Yeah, may I put it this way, Your Honor? You have the book. If Your Honor look at the Revenue Authority Act again, please, Your Honor. I hope it's the last time.
President, I wonder when I could ask the Council to review.
Well, you ask him
if this act, if the constitutionality of the Revenue Authority Act has ever been challenged.
Your Honor, that is now an issue before the courts. The act is being challenged for its constitutionality. I cannot anticipate what's going to happen, but it's being challenged.
You referred it to the decision by the present Chief Justice.
True, and others?
He was at first instance.
That is under challenge right now. It might be heard shortly.
His ruling challenged the constitutionality of the act.
His ruling said it was constitutional, but the appellant too, and all the others are saying it's unconstitutional. It might be heard shortly.
It's under appeal.
Under appeal. Your Honors, let me put it this way. In terms of Section 32 of the Act.
Could you wait a minute?
Just forgive me, please, Your Honor. 42. Yes, okay, yes. Give me the constitution.
Mr. Gibson, before we get on to that, I don't think that you quite adequately answered my brother Nelson. When he asked whether there was anything in which the terms and conditions of this employee was he sent a document saying
No, Your Honor. Let me tell you what has happened. Section 32 of the Revenue Act gave the minister power to make regulations that may be necessary for carrying it into effect. The minister has not made those regulations, and that was part of the case before the London trial judge in Guyana.
But when he was taken on, or this group of employees were being delinked from the established public service to the Revenue Authority, did they have any document saying, as of this date, you will now be employed by the Revenue Authority on the following terms and conditions?
No, Your Honors. No, Your Honors. None. The regulations were to be made and they were never made. And I suppose they were not made because of Section 6.
But were they told orally that as from this date you shall be now employed with the Revenue Authority?
No, Your Honors, none. Your Honors, may I answer a question which was posed to me by the London President? Under the Guyana Constitution, our Article 153 makes no provision, as in Trinidad or Barbados, as to how you must come. You can approach the High Court in any way. Our Article 153 has been amended. It has been amended. That's to say...
What does it
It says now, in any proceedings, in any court subordinate to the High Court, if any question arises as to the contravention of any provisions of Article 128 and 151 inclusive, the person in that court shall remit the matter to the High Court, unless it's an opinion. The raising of the question is merely frivolous or vexatious. Formally, that section limited you. You can approach the court in any way in Guyana, in any way, in any form.
Does your case depend in part at any rate on treating the applicant's office as property?
As property, yes, Your Honor.
Yeah.
Yes, Your Honor.
Is that
it is property.
Consistent with the authority that exists?
I am treating it as property, Your Honor.
Yes, but I'm asking, do you have support for that in the decided cases?
Article 146A of the Constitution, 144A, Article 149A of the Constitution of Guyana, which is a new amended section. No person shall be hindered in his enjoyment of his or her right to work. That is to say, the right and freedom to choose his employment. And Article 142 of that Constitution, of our Constitution, was interpreted in the case of Inland Revenue Commissioner and Lilliman, and it says that money was property.
Yes.
And I am saying that what this man applicant lost was money, and money is property.
What money has he lost?
He has lost the income that he was getting, the income that he would have got from his job when he was sent off. He has lost it. He was sent off without anything at all. His gratuity, his pension, nothing at all. He had went without bare hands. And that is entitled to protection.
He has been deprived of the opportunity to
earn it. Yes, sir. That is so, sir?
He hasn't been deprived of money in his possession.
But what I'm saying, Your Honor, he wasn't deprived of money in his possession. He has been deprived of money that he has earned, money earned or accrued under the pension by way of pension. That he hasn't got. Money earned, accrued, inchoate or contingent.
Doesn't the section which deals with the right of property treat property as something which can only be legitimately taken away if there exists some provision in the written law for compensation? Is that right or not?
142. Written law for compensation.
How is Article 142 relevant to these circumstances?
I am saying with respect, Your Honors, the section 6 says, rights which have earned, accrued, inchoate or contingent. What he has...
Of 142?
No, I was referring to section 6 when you spoke to me a little while ago.
I was asking about Article 142. You said protection from deprivation of property.
Yes, Your Honor. I am saying that his pension was property.
Yeah, but does 142 envisage pension?
Yes, Your Honor, it does.
Well, I don't know. Reading it as it is, it seems to provide for property compulsorily acquired by the government. And you cannot take it away compulsory unless you provide compensation. It seems to be, the whole tenor of that seems to be this.
If I may say politely to Your Honors and to the court, pension is property.
So that would not, however polite you might be, I mean, that may not be law.
I think I really didn't walk with it, but there's substantial authority on that, several authority on it. I know, I don't have it with me.
Because you rely on 142 and reading it.
Yes, Your Honor.
I don't see that it envisages that type of situation. Which section of it covers that?
It says no property of any description. 142.
Shall be compulsorily taken possession of.
Yes, Your Honor. I am saying with respect, when he was sent off those premises, sent away, said, go away, you have nothing. He left all that he had behind. What he had behind was taken from him. There's no way he can get it.
What? What was in his desk or what?
He lost what he had earned. Because his pension had been earned.
What he had was taken.
I don't get you.
It shows in action.
Oh,
It shows in action.
it shows in action.
It shows in action.
Yes, Your Honor. A shows in action is property. A shows in action is property. I think that the case of Mahmoud Job.
Taken from him.
In Mahmoud Job versus the Attorney General of Guyana, shows in action was deemed as property.
Aren't you in court? Can't you go to court and get whatever the value of your shows in action is?
Exactly.
You can go to court.
So how has it been? How has it been taken away from him? What's taken it away from him?
What really happened? The protection of the law is there for everybody, I agree. When he was sent off, the protection of the law would send him to go to the court and get it. But I am saying, with respect to you, Your Honors, when he was sent off the premises, he had no way of getting it unless he probably had to find money to find the retained lawyer, retained counsel, and go and fight the court for it. There was no way he can get it.
Didn't he have to do that anyway?
Now, Article 142.
Yes, read 142.
No property of any description shall be compulsory taken possession of, and no interest in or right over property of any description shall be compulsorily acquired, except by or under the authority of written law. and where provision applying to that taking of possession or acquisition is made by a written law, requiring prompt payment of adequate compensation.
What do you think that refers to?
When it is word property of any description, it will include shows in action, a check, anything, Your Honor.
That were compulsory taking possession of?
Yes, Your Honor, because I'm saying in this case, there's nothing he could have done about it. He was chased, he was sent off. He can't get it, he can't reach it.
Don't you think this is stretching it rather thinly?
Well, I use the words of property of any description.
What was the intent behind this section when it was incorporated in the Constitution?
Was to prevent the government from confiscating people's property.
Compulsory
confiscating
acquiring property without compensation.
Yeah,
Yes.
It was also to protect.
Was it envisaged that it would cover, as you say, shows in action, pensions, things of that nature?
Yes, Your Honor. I am of the opinion that where people were dismissed or sent off their jobs, and the government refused to pay them their money.
But was there a refusal here? Did the government refuse to pay?
Well, if I may endorse what you say, it was not a refusal as such, but it was to my mind, it was a deprivation. It said, get out of here, I don't have anything to give you.
But you haven't even brought an action in court. So how do you know that they refused?
Well, I must concede the action was brought. The action that was brought is what was before the court and turned down.
That's why I asked you earlier whether you were challenging the unfairness of the dismissal, because by your constitutional motion you seem to be relying on the taking away of property rights.
Yeah.
Which means, I don't know whether you're challenging the correctness of his being dismissed.
That is the basis of the thing. That is the genius, that's the basis of it. So when we put you off here, it's unfair. I've lost all that I have.
But isn't the root of your complaint the fact that he wasn't given a hearing?
That is the basis of it. That is the down at the bottom. That's down at the bottom, Your Honor.
Doesn't that provide a firm foundation for a prerogative writ?
Your Honor, that is one of the ways to approach the court.
Use that.
Your Honor, because I'm of the opinion that there was a public law right that was involved. So I can come by way of declaration. Pick that company says you could take one or the other.
You could have come by way of a declaration, yes, and it was void, but you didn't.
Which I did here because, under the law of Guyana, Your Honor, there is a special provision.
Mr. Gibson, just a minute. What I'm trying to find out
yes, sir,
is why it is you chose to come for constitutional relief on an action claiming that your rights under the Constitution had been contravened, when you could have come either at common law for a declaration that the dismissal was void, or you could have come for a writ of certiorari to quash it, and whatever consequential relief would flow from that.
Your Honor, if I may say with respect to you.
I would just point out to you that, not that it is a binding precedent, but the Judicial Committee of the Privy Council has held that when there are factual issues to be investigated, and there are other alternative remedies available, a constitutional motion ought not to be resorted to, and that they treated that as an abusive process.
Your Honor, if I may say with respect, Your Honor, in Guyana that provision no longer exists.
What provision?
The provision that you not come by constitutional motion. That is the provision that you are not to come by way of a constitutional motion.
There's no provision to that.
No, not in Guyana. That has been taken with the Guyana Constitution. Trinidad has it, Barbados has it, no, they don't. But Trinidad has it, and so on, but in Guyana it has been removed from the Constitution. We have a recent amendment that removed it.
Trinidad and Tobago does not have it. Does not have it.
I can't remember the name. But in Guyana, we have an amendment which removed that from the Constitution.
Remove what?
Remove the fact that you don't have to exhaust the other remedies before turning to the Constitution. You could take any remedy that is available to you.
Yes, I know, but...
Any remedy. No longer part of our Constitution.
But you see, by coming this way, you have run into a lot of problems which would not have existed if you had used the other avenues, such as the question of whether the public service regulations applied, or whether your office was property. Those are really quite unnecessary complications, which we ought not to be troubled with.
Let me see a picture of my company here. Could you find it for me? Your Honors, I have with me here an authority from India, the case of Turkdev versus Bhagat Karam. I think it's page 68 in the book of records.
It starts at 54.
Yes, page 68.
It starts at, isn't it, Sukhdev Singh?
No, yes, but I've Sukhdev Singh.
It starts at page 54, but you're referring to what?
Page 68. Letter A. Constitution, therefore, should, wherever possible, be so construed so as to apply to arbitrary application of power against individuals by centers of power. The emerging principle appears to be that a public corporation, being a creation of the state, is subject to the constitutional limitation of the state itself. The preconditions of this are two, namely, that the corporation is created by the state, and the existence of the power in the corporation to invade the constitutional right of the individual. Find Pixpan and Company for me. He said that I'm going to.
I was going to ask you, what is your opinion of the Trinidad case of Perch against the Attorney General?
If I may say with respect, there is in just one minute. The case of Porch is more akin to the English case of Tanner and Hannaford. One is the government in business, and one is the government as part of the executive. In Porch's case is the case of the government in business, which is different from the government as the executive. That's the major difference.
But you're
If the
saying-
government goes into business, it's different.
But you're saying the establishment of the Revenue Authority was the government, was an executive.
As an executive act, they collect money for the government, the money is paid into the consolidated fund, the officers are immune from suit. It is government. It is what was said by Idu J in Ramgolam's case. You're immune from suit, you collect money for the government, and so on. That is what this corporation does. It's immune from suit.
It's not government in business, as you say.
Is that the government in business?
Because it covers the customs.
They're only customs. They're collecting dues. Not the government
It
in
also
business.
cover the income tax department.
The income tax, well, the income tax. The two revenue earning departments are covered by it. It's not the government in business. In Martha Porter's case, it's like Tamden and Hannaford. The government in business. It's different.
The collection of customs duties and etc.
It's a revenue matter. It's a state matter. Only the state can collect revenue.
Is it a part of the business of the government?
No, Your Honor. May I put it this way politely and with great respect to you? Only the government can collect revenue. Nobody else can.
But because in Perch, the Privy Council, the board of the Judicial Committee of the Privy Council, differentiated between persons who were they were delinquent from the
Yes, Your Honor.
service,
Yes, Your Honor.
and they became employees of the corporation or statutory body that had been established.
Yes, Your Honor.
And they were no longer regarded as public.
They were no
officers.
longer, like as we said, Tamden and Hannaford, the British Railways.
Different, in this case is different to that.
Different, Your Honor. The British Railways, different, completely different from the government as the executive.
Could you repeat your earlier argument about the executive and the government in business for the benefit of the President and my...
In the case of Martha Porch, it's the government in business, and in competitive business too, which is different. It's like the case of Tamden and Hannaford in England. The government runs the railways, it has to compete with private people doing transport. Completely different. That the government is part of the executive. As part of the executive, the government has no competition.
But if I recollect from reading this case, I think they did have a similar provision as the Revenue Authority, where the persons are transferred over on terms no less favorable than they enjoyed whilst in the public service.
Yes, Your Honor, but basically, the post office is in business, in Martha Porch's case, competing with fax machines and other people doing private postal work and so on. So the prices got to go up and vary. You don't have to go to the executive every minute to get a change in stamps or to increase the cost of this. The government is competing.
And you say that makes a difference.
That makes a completely wholly different. The government and the executive has no competition. The government in business, they pass a law tomorrow, we all have to obey it.
Mr. Gibson, we don't really want you to go into the substantive argument.
I concede that, Your Honor. I concede.
Any great
I concede.
and perhaps now you could at least sum up what your case is with regard to the contravention of the Constitution. If you can just put it in a few sentences, what the substance of your case is.
May I put this way, Your Honors? My respectful submissions in toto amongst this: A, that Section 6 of the Act underpins the status of the applicant. That is to say, it preserves to him all the rights that he possessed immediately before he joined the department. Immediately. And that is the operative word.
Yes.
Secondly,
B.
by removing him in a manner and form in which the head purported to do, he interfered with the fundamental right guaranteed to the applicant by depriving him of the security of the fundamental law, that is the fairness test.
Yes.
In fact, the applicant was deprived.
This is C or?
In fact, we can make it here, Your Honor, please, Your Honor.
In fact, okay.
The applicant was deprived of what was said in the case of Crane versus Reeves. The simple test of allowing him to say something in his own right. Why you shouldn't throw me out.
The right to be heard.
Yes, sir. Yes, sir. Yes, Your Honor. C.
Is it C or D?
Oh, just tell you, I said C.
So this is what D?
C, he said.
Yeah, I'm being reminded that it should be D.
Should be D now?
Yes, sir.
Oh, okay.
The applicant, as far as his superannuation benefits were concerned, since he held the status of a public officer, ought to have been given the right not only to be say something in his own defense, but to be compensated. He had to be compensated before being sent away.
Yeah.
The relationship between another reason, please. It's another reason, please. This will now be C, the E. The relationship between the applicant and the respondents was not one of master and servant. And the applicant was dealt with as if he was employed at pleasure.
Yeah.
There is no way in the statute.
This F.
Yeah, F, sir. Please, Your Honor.
I think he was employed at pleasure.
As if he was employed at pleasure. He was dealt with in that form. As if he was employed at pleasure. In other words, you could knock him up without notice or without anything.
As though he was an old-time civil servant.
Yes, sir. I dealt with an old-time civil servant.
Yeah. Yeah, the next one.
Yeah, that's what I'm coming to, Your Honor. Parliament had authorized the authority to make regulations for the management of the authority. And these regulations were not made. And accordingly, there was no way of abbreviating the applicant rights. No rules were made, none was made.
Does that mean they could not dismiss anyone?
No, that doesn't really mean that, sir. What it means, it doesn't mean that you couldn't dismiss anyone.
No.
You could still dismiss, but then it means that you have to follow the rules of natural justice. You have to do it. Have to do it. If you don't make the rules, it doesn't mean you can't dismiss, but you have to obey the fundamental law.
But even if they made regulations, they would still have to obey those rules, wouldn't they?
Yeah, the regulations would among the rules, Your Honor, the regulations would have had statutory force. Because the regulations referred to in this book had to be laid before Parliament. The Act provides that the regulations were to be laid before Parliament. That it is, Your Honor. That is, Your Honor. And may I, before taking my seat, may I thank Your Honors for the manner and form in which I've been heard.
Thank you, Mr. Gill. Yes, Mr. Barrage.
My lord. My honor. My honor, I principally rely on my skeleton submissions that I have filed in this matter, which attempts to make the point based on the Act. That the Section 8, which is of the laws of Guyana, Section 8 of the Caribbean Court of Justice Act requires that this court grant special leave in criminal or civil matters. And as my lord and my honors have earlier, I think my friend agrees that this is not a civil or criminal matter. And he agrees that this is a matter coming within Section 60, and therefore no leave is required. In those circumstances, Your Honors, my submission...
Is it true to say no leave is required? May not be required by the Act, but is it not required by our rules?
Definitely, Your Honors, no leave is required by the Act. And therefore, I confine my statement to no rules required by the Act, and I agree with Your Honor's observation that Section 10 does require leave. But it is my contention that in a leave application under Section 6 of the Act, the considerations are different as to a leave application under Section 7 of the Act. Under Section 6 of the Act, the issue to be determined is whether any of the provisions of Section 6A to E inclusive would have been established. Therefore, you will be allowed to proceed as an application being an application without the need for leave. So that it is correct to say under the rules that it is styled an application for leave. It is not the same to say in my submission that it is a leave application as is contemplated by Section 7 of the Act.
But since the applicant has an appeal as of right, ought he to be deprived of that right because of his failure to apply to the right quarter or the leave, that is to say, the leave which would involve the prescribing of the security and any other conditions that would attach, or he to be deprived of his substantive right because of his failure to do that in circumstances in which the coming into force of the CCJ Act apparently was not or may not have been widely appreciated in Guyana. I don't know, perhaps you can help with that.
Unfortunately, my lord, I am a practitioner that normally reside in Trinidad, so I really can't assist the court to the extent that my lord invites. My friend who appears on behalf of the Attorney General practices in Guyana. My lord, may I simply say that I'm not attempting to deprive my friend. What I'm suggesting, my lord, that there is a procedure provided and that should have been followed. My friend cannot complain of a deprivation of hearing his right of appeal when he has chosen an erroneous procedure. And I'm suggesting to my friend that what should have been done is an application should have been made under Section 6, following Rule 10, and an application to extend the time given the circumstances that were peculiar to the position in Guyana, which would have been within the knowledge of the Court of Appeal of Guyana, who would have been in a very good position to appreciate the factual matrix underpinning the application for leave, and to dispense with the rules insofar as it prejudices my friend bringing an appeal out of time. So that my contention, however, with respect to an application under Section 8 is that the court does not have the jurisdiction under 8 to entertain the application, it not being a civil or criminal matter. If I am right on that point, then if the court does not have the jurisdiction to entertain the application, then it is my further submission that the court does not have the jurisdiction to exercise a discretion in my friend's favor.
You submit that section, or rather Rule 1.42, is it?
Yes, my lord.
That doesn't really provide us with a means of giving the leave that is being requested, notwithstanding the limitation in Section 8. That doesn't help.
It is my contention that it does not help for two reasons. And if I may, my lord, the first reason being that, could I read the rule, my lord?
Yes, please.
10.1.4, I think subsection 2 is what my friend is referring to. Nothing in these rules shall limit or otherwise affect the inherent powers of the court to make such orders as may be necessary to meet the end of justice or to prevent the abuse of the process of the court. There are two things I wish to emphasize in that rule. It refers to the inherent power of the court, and it states the purpose that the inherent power of the court must be exercised. That is to prevent an abuse of the court's process. First of all, my lord, it's my contention that you cannot revert to the inherent power of the court when there are specific rules governing what procedure that ought to have been adopted. My understanding of the inherent power of the court is that it will be exercised in circumstances there are no express rules made to deal with the situation. And secondly, my lord, what is the purpose for the exercise? To prevent an abuse of the process. My friend cannot be heard to say that because he has failed to follow the procedure as outlined in the rules, the court must now, that is preventing an abuse of the process. I thought it would have been the converse. So the rules, sorry, my lord, my honors.
The other limit is to meet the ends of justice.
And they
I
don't
think he has argued that it would be an abuse of the process.
Okay, so that my sorry.
The meeting the ends of justice, in that he has, as of right, at least on prima facie, a right to an appeal.
Well, we concede. I concede that. Yes.
Does the fact that the form of his coming here have a limit his right to have justice?
I thought it would have been limited by the rule by section 6, 7, and 8 of the Act. I don't think, my lord, that the ends of justice there would be such as to take a matter in which the court would not have jurisdiction and to be powerful enough to impose into the section a right to grant leave.
You say jurisdiction,
yes, my lord.
But you
my
agree
honors.
that he has an appeal as of right. In other words, he can bring an appeal in
yes,
the
my lord.
Caribbean Court of Justice.
Definitely.
As of right.
Yes,
the only question is, what are the mechanics and how does he get here?
Yes. And sorry.
He got here by the wrong road, but he nevertheless got
reached
here.
there.
The question is whether Rule 1.4 sub Rule 2
can cure it. In the end of justice.
Us not having jurisdiction. He's got here.
Yes, my lord.
By the wrong road.
Well,
can I just have 1 minute, please? My lord, one would have bypassed section 13.1 in that process. 13.1, the Court of Appeal may grant leave to an appeal in accordance, my lord, I'm referring to the Act, 13.1 of the Act. The Court of Appeal may grant leave to an appeal to an applicant in accordance with this section. And 2 says, leave to appeal shall be granted to an applicant upon conditions that the applicant during a period fixed by the court not exceeding 90 days. And what the point I made in my skeletal submission in this limb of it was that what would now happen, you will get into the second limb of my friend's argument, that really what in fact he is before this court for is to dispense with with the requirement to appear in corporis. So my lord would have to go in.
Follow that argument.
Sorry, my lord. I am sorry. My lord, argument or questioning on 141 was that it meets the end of justice.
1.42
of the rule, my lord, which gives the court 2. Yes, my lord, which says, I just read it, application of the rules, inherent power of the court, end of justice requires, look, regardless of how he's gotten here, we now need to regularize it and we can have the jurisdiction. What would happen if my lord entertains this application, albeit they have no power under section 8? It'll be preventing the Court of Appeal from exercising its discretion with respect to 13.2, which would have been, that is the question under 13.2a, security for costs.
What does it say?
Malad, could I read it?
Yes.
Leave to appeal A shall be granted to an applicant upon a condition that the applicant, within a period to be fixed by the Court of Appeal or the court, but not exceeding 90 days from the date of hearing of the application for leave to appeal, enter into good and sufficient security to the satisfaction of the Court of Appeal for the due prosecution of the appeal and the payment of all such costs as may become payable to the respondent in the event. The security here has to be to the satisfaction of the Court of Appeal.
But that's when the Court of Appeal is giving leave to appeal and it sets out the conditions on which you get to the Caribbean Court of Justice. What would have been the procedure for approaching the Court of Appeal in order to get leave and to get these conditions fixed? What procedure?
That I understand, my lord, would have been covered by
I'm asking what are the Guyanese procedures? What procedure on the
well, that as I understand the Guyanese position, no rules have been made by Guyana with respect to the approaching the Court of Appeal. I would defer to what my friend has to say, but that is my understanding of the position. The only rules affecting the movement from the Court of Appeal of Guyana to the Caribbean Court of Justice are the rules that have been made by this court and have been incorporated under Section 3 as with the force of law in Guyana.
What is the last rule you were reading from?
Milad, I was reading from 13 of the Act, Milad.
13 of from the Act. What you were reading?
No, my lord. Milad, I was subsequently asked about the rules. 13.2a.
1-2A.
13.2?
13.2A.
1-2. It's 2, isn't it?
Yes, that's
13.2a.
I think your point is that the court below is the one that should fix the security
Security
for
for
costs and so on.
costs,
But I would wanted to draw your attention to Rule 10.8 of
10?
the 8A of the rules,
Rules, yes, madam.
which also provides for it to be done by this court.
Yes,
So
Your Honors.
even though you didn't get it done in the court below,
Yes, madam.
this court can also fix the security for costs.
My lady, Your Honor, I would read this rule in the context of the court having a jurisdiction under Section 8 of the Act. If the court has jurisdiction under Section 8 of the Act in a criminal or civil matter, obviously the court must have the consequential power that flow from that section to give effect to it by setting the requirement. That is why I thought that the first objective or hurdle my friend had to overcome is to show that there was a section of the Act which empowered him to make the application. If there was some, having had jurisdiction to entertain the application, if there was some impropriety in not being timely in prosecuting or entering, I thought this court, of course, would have inherent power to exercise to ensure that the ends of justice are met. But I'm submitting, Your Honor, that that's a different situation from this matrix. In the factual matrix before the court, the application itself is flawed. This court not having jurisdiction to entertain it.
But I go back to the point. What means that we have no jurisdiction? I mean, if he makes the application and he says, well, look, I didn't go to the Court of Appeal in Guyana because there was no procedure laid down for my making that application there. Is not one of the points that he's making?
He isn't forgetting he should be.
I am guided by what my friend said and what he said. But to deal with that position as it presents itself, even if he says that, or even if he should have said that and he didn't say that, my condition would be, yes, fine. On what basis is this court is receiving his application? Sorry.
Could I draw your attention to Section 4.1b of this Act, which clearly requires the court to have an absolute jurisdiction provided for in this Act, as is conferred on it in accordance with the provisions of Part 3 of the agreement.
Yes, my lord. Yes, my lord.
The provisions of this Act
Yes, my lord.
are not in accordance with Part 3 of the agreement.
Well.
No, you will
Yes,
look
my
at
lord.
it quite carefully. Section 25, 2, 3, and 4 of the agreement.
Section 25.
5, 2, 3, and 4 of the agreement.
Article 25. No?
Sections 25,
articles.
Yes, Article
25.
25, 2, 3, and 4 of the agreement
Yes, my lord.
do not correspond to Section 6, 7, and 8 of the Act. And there was clearly a drafting error where the Act speaks of subject to Section 7. It should in fact read subject to Section 6. Because if you look at the agreement, you will look at Article Section 25(4). It says subject to paragraph 2. And the paragraph 2 corresponds to Section 6 of the Act, not Section 7 of the Act. So there was clearly a drafting error here. And insofar as this Act does not correspond with the agreement as the Act prescribes, the agreement is controlling. This is also a part of the Act.
Definitely, by Section 3.
So the question of this court not having jurisdiction could not and does not arise.
Yes. Millard, those are my submissions. And Millard, I looked at the decision of this court, Millard, in the case of Barbados Radiofusion Services Limited and Merchandani, which emanated from the Appeal Court of Barbados, Millard, with particular, Your Honor, Mr. President's judgment at paragraph 33, which I felt addressed the issue that Your Honor was putting to me. And if I may be permitted to just read it, it's about 10 lines. Although this cannot be said to be an aid to the interpretation of the CCJ Act, it is to be noted that the rulemaking authority has proceeded on the assumption that a party may apply to this court for special leave, either having made or without having made an application for leave to the Court of Appeal. Rule 10.4 of the Caribbean Court of Justice Appellant Jurisdiction Rules 2005, the Appellant Jurisdiction Rules, provide alternative time limits for the making of an application for special leave, depending on whether or not such an application has been preceded by an unsuccessful application for leave to the Court of Appeal. These time limits are 42 days from the date of judgment from which the special leave to appeal is sought, or 21 days from the refusal of leave to appeal by the Court of Appeal. That is why when my Lord President had posed the question about the interpretation of Section 6 into Section 7, I answered him in a particular way because I understood the issue before this court is how do we deal with that in the context of an application that should have been made under Section 6 and was not made at all. Do we now say, contrary to the agreement, in fact, contrary, if the drafting error was not made, what should have happened, my Lord, with the greatest of respect to the draftsman, is that it should have been subject to Section 6. And the real issue, I would assume, is how do we construe the words of Parliament to give effect to an error of drafting? And that is why I have taken the position, Millard, that it goes to one of jurisdiction, and that there is no jurisdiction granted to this court to entertain an application governed by Section 6, where there has been an absence of an application under Section 6. And my friend cannot pray in aid to cure that omission. The rules of court made pursuant to the rulemaking power of the court.
You say that we cannot grant special leave if no application has been made to the Court of Appeal in a case in which there is an appeal as of right.
No, Miller. I was a little more specific than that. Oh, I meant to be a little bit more specific than that. I was confining it to Section 6. Section 6.
Well, in Section 6.
D, which is
where there is an appeal as of right.
Yes, my lord. I did not, because you see, Miller, the problem with confining it to all applications, given the history of the draft and error in this situation, Miller, I was in Section 6A, for example, it starts off, in any civil proceeding where the matter in dispute to the appeal to the Court of Appeal is of a value. It would seem now, Miller, that an application under 6A, which is a civil matter, falls within the jurisdiction of a civil application for special leave under Section 8 of the Act. But, Milad, you cannot use such an interpretation to widen the definition of civil proceedings to include all the applications under Section 6. In particular, you cannot... Well...
Which ones does it?
Milad, that question does not provoke an easy answer. And it does not provoke an easy answer for this reason. That if my Lord takes the position that the Act, it has to do with how you construe the interplay between the treaty and the Act in light of the omission to use the words provided for in Section 6.
Provided for?
Yes, Milad. Subject to Section 6 in Section 8.
So what is that? I don't know that those words are so crucial. What does it mean? If you add it, what difference does it make?
What I think it takes, and it puts beyond doubt, Milad, that applications under Section 6 are exclusive to the citizen, and he does not have to seek leave. He has it as of right. And the only question for determining is the procedural provisions by which that right is expressed. And he must come before the Court of Appeal and
I don't think whether it's subject to is there or not, that there could be any doubt about that.
No, my lord. There isn't any doubt. My lord, and my contention...
I'm really trying to understand you, but I'm afraid I'm having some problem in understanding your solution with regard to the exclusion of this court's jurisdiction from dealing with applications for leave when the matter falls under Section 6. You seem to say that you said it's a difficult question to answer when it would be excluded and when it wouldn't.
Yes, my lord.
I don't know why do you say it would be excluded at all.
Well, my lord, if you use the word civil or criminal in Section 8 to be the gate that determines what comes to this court under Section 8, then clearly any fundamental rights provision would not fall within civil proceedings. I'm not sure, it's not as clear, my lord, in my submission, whether civil proceedings where the value is less than $1 million or where it involves a direct claim or a question in respect of the right of value of goods to that effect. It is...
I thought we had made that judgment of mine that it had been made clear that when it was a Section 6 case, normally we would expect that they would go to the Court of Appeal, and that therefore they came to us instead of going to the Court of Appeal for no good reason. We might turn them away.
Yes.
In other words, Section 8 is really intended to be applicable to cases where there is no appeal as of right.
Yes, madam.
That's prima facie. But if there was some special circumstance, As for instance, if the Court of Appeal had refused to grant leave in a case in which there was a right of appeal, and there was an application for special leave, I would like to think that we might consider giving special leave in such a case, although I'm not making any pronouncement on it.
Yes. My lad, sorry.
And so that I'm not clear as to what your submission is really with regard to this. I understand the submission.
Yes, my lord.
That we have no power to grant special leave in any case which is neither criminal nor civil.
Yes, my lord.
Right?
Yes, my lord.
I understand that. But I don't understand the submission which is linked with Section 6.
My lord, could I rely on that as being the extent of my submission in this case?
Well, it has the merit of being understood at any rate.
Yes, my lord. I never suggested it. But
may be my fault, not yours.
No. My lord, I was taken on a path much wider than I did in my skeleton argument, and I was attempting to grapple with it on my feet, and maybe I was not as clear as I should be. My lord, and the reason I was taken on that path is because I was referred to the treaty that went with it, and I was trying to impose the treaty on it. But, my lord, for the purpose of this case, my lord, I pin my submission that this application... Sorry, my lord.
Yeah, but before you go off the point, I am grateful to you for drawing attention to Section 13.2, where there seems, I don't know, my brother Paul may be able to help me because it's a drafting matter, but there seems to be some deficiency in the drafting here. Does leave to appeal shall be granted to an applicant upon condition that the applicant, within a period to be fixed by the Court of Appeal or the court, that is this court, but not exceeding 90 days from the date of the hearing of the application for leave to appeal, enters into good and sufficient security
to the
but then it goes on to the satisfaction of the Court of Appeal. And there it seems to me that the words or the court should have come there at that point.
Court.
Because it's obvious, it's hardly, it could hardly have been intended that the amount of the security should be fixed by one court and the time for providing it fixed by another. I think that this set out to provide that whichever was the court that was granting the leave should have the responsibility for dealing with all aspects of his security.
My lord, I must say that I made the submission after seriously considering this, and my lord, I think it comes of significance of greater significance when one considers the second limb of my friend's application, which is to apply in pauperis.
Well, yeah, we have a complication of what we are told was a decision given about a week ago.
Yes, my lord.
In which the Court of Appeal have held that they have no power to grant leave to appeals of a person.
And my lord, I would, without seeing the reason, feel that this section would have played some way in the Court of Appeal's interpretation of its power. I was not there when it was argued, no, but I felt it would have.
But I don't understand why that is so, because surely the the ability or the empowering a court to fix security doesn't preclude them from dispensing with it, does it?
See, my lord, there is also section 17, which speaks. Sorry, my lord. I was trying to refer, my lord, to section 17.1, section 1 and 2 of the Act as well, which it says here. Could I read the letter?
Yeah.
Where the court directs, that would refer to this court.
Section 1?
17.1.
Yeah.
Where the court directs a party to bear the cost of an appeal, such cost shall be taxed by the proper officer of the Court of Appeal in accordance with the rules for the time being regulating the taxation in the Court of Appeal. May I pause to say that is how I rationalize why the words or court was not included in the section 13.2a, because I understood the schema of the Act to require that the question of the appropriate quantum to be set for cost and the actual quantification, if it happens subsequently, to be within the jurisdiction of the Court of Appeal of the jurisdiction from which the appeal emanated, and ought not to be entertaining the attention of this court. That is how I...
What sense does it make to provide for the time of providing the security to be fixed by this court?
Because, my lord, I would think that in setting the security for costs, my lord, a court in exercising its jurisdiction and determining the quantum would take the likely quantum to be awarded as a factor in setting the quantum of security that ought to be put up by the appellant.
You are not answering my point.
No, I'm sorry. I'm sorry if I didn't.
What sense does it make?
Yes, sir.
To give to this court a power to fix the time for providing the security when the quantum of the security is to be fixed in every case by the Court of Appeal? What sense does that make? The Court of Appeal going to send it to us to fix the time? I mean, that would be absurd.
My lord, I don't mean to be able to answer every problem of this act, but what I would prefer in purporting to answer my lord's question, my honest question, is that I felt in looking at these sections that the problem that was being grappled with is how in a region in which you have so many diverse jurisdictions, when quantums would vary in jurisdiction to jurisdiction, would be a fair way to set quantums to the respective jurisdiction. And that is why I felt there was an attempt. I will not pronounce...
I understand your point about if they are going to fix the cost ultimately, they're going to tax the cost in the local court, then the local court should really fix their quantum of the security.
Yes,
I understand that.
I see, but the question
what I'm saying is that you've got to make sense of the
other
section as a whole. You can't, with all due respect, say that and that question is too difficult, so I'm not going to deal with it. If it bears on the overall sense of the section and what was intended, and to stick it or the court in the first case and not the second, doesn't seem to me to make sense. And unless that can be explained, then it leaves it open to conjecture as to whether it is a drafting error or what.
Definitely, my lord. My lord, if I may go back to 13.2a, leave to appeal shall be granted to applicant upon the condition that the applicant, so there is no discretion. It is mandatory that security for cost be put up. There is no discretion.
Where are you reading?
13.2a. 2a.
This is section?
Yes, my lord. The same section that my lord has asked me about.
Yeah.
So leave to appeal shall be granted to an applicant upon a condition, so that the condition is mandatory, that the applicant, all that is in the discretion of the respective court is the period and the quantum.
13.2a.
This is the same section I had read earlier, my lord. I'm just going over to make the point that, my lord, there is a mandatory provision and there are two issues of discretion. The first issue of discretion is the period which is given to both courts, and the quantum, which is the second issue of discussion on my submission, is given to the second court. Sorry, my lord.
I would like to ask is, why can the court, as in a normal high court case, why can the court not say no, that's the cost, or that why can the court not say no, that's the cost?
I don't think, my lord, that if I suggested it, I'm sorry. I did not suggest the fact that in setting the quantum, it had taken away a power from the court to make no orders as to cost. I did not mean to suggest that.
The court may decide that no party
should bear any cost, and the court is correct to make that decision.
But if it does so in advance, can it not also decide that security need not be provided?
Well, my lord, I would submit that on the wording of section 13.2a, it does not seem to give the court such a power. It shall be granted to upon the condition. It seems
a very restrictive
interpretation.
But you know, coming back to your main point that the quantum can only be fixed by the Court of Appeal, but that's really quite unworkable. But it means that whenever there is an application for special leave, what is to happen? How is the security to be, the quantum of the security to be fixed? How is it to be done?
Yes.
Tell me.
May I suggest, my lord, that what would happen is that there is an application for leave before the Court of Appeal.
No, there is no provision for leave to the Court of Appeal, because this is not within either the 6 or 7. I'm dealing with a case where it's let us assume that is your cost wouldn't be involved in a criminal case. Let us assume that it is a case which is not within 6 or 7, but where you are asking for special leave.
May I put in one rider on the answer I wish to give, my lord? That it's difficult for me to anticipate a case in which it will not be governed by section 6 or 8, and there still will be a valid cause of action to come to this court. But in the event that there such a thing exists, my lord, what I would submit is that on leave, special leave being granted by this court, the matter thereafter with respect to the security for cost and all the procedural provisions would revert to be governed by the Court of Appeal of the jurisdiction from which the cause of action emanated.
Might I draw your attention to Rule 10.8 of the CCJ rules?
The rules. 10.8?
10.8.
Yes.
8A and B.
Where either the court or the court below grants special leave to appeal or leave to appeal as the case may be, it shall determine whether the application should provide security for costs, and if so, shall specify the amount of the security and the form in which the time for which it should be provided. And B, shall provide for the transmission of the record by the proper officer to the registrar.
So all that empowers this court to make an order for security for it, in the event that we grant special leave. Wouldn't you agree with that?
For me to agree with that, milady, Your Honor, I would have to agree that there is a power in the rulemaking committee to take the rules outside the ambit of 13.2a as I have submitted.
But what about, I know it's a general provision, but what about Section 2, which specifically says that the rules shall have the force of law?
My Lord referred to Section 3? 3. Yeah. It says, my Lord, if I may read, it's a very short provision. The agreement and the rules made thereunder shall have the force of law.
Well, aren't the rules that they refer to there,
yes,
the rules of court?
Yes, my Lord. And the question is, they'll have the force of law, my Lord. I would submit, my Lord, that can't be construed as giving the rule-making committee the right to draft a rule that is in conflict with an express provision of the Act. I would try and I would seek with all strength to interpret it so as to give harmony rather than to provoke conflict.
Well, I think we have to interpret the Act and the rules not only in a way which would produce harmony if possible, but which would also make sense.
Oh, definitely.
And I don't see that providing on the one hand for an applicant or a person who wishes to appeal to go straight to the Caribbean Court of Justice and not to go to the Court of Appeal, because the Court of Appeal presumably cannot deal with the matter. Why that person should be required then by some form of application which is not indicated anywhere, should have to go back or go to the Court of Appeal merely to get the quantum of the security for cost established. That to me doesn't make sense. Make sense to you?
Well, I'm trying hard to make sense out of it, and I must confess I do have a lot of difficulty, my lord.
Well, why not just say no?
Well, I noted in the case emanating out of Barbados that counsel in that matter had declined the court's invitation to make submissions on Section 7 and 8, and I thought that was a rather regrettable position, because, my lord, in construing the question that my lord has just asked, and I say this with the greatest of respect to your honors and all who participated in that decision, I thought that may have been a reason why the words provided for in Section 8, subject to Section 7, may have had a meaning different, albeit, to what was contained or within the agreement. And the question which I attempted to ponder but could not come up with an answer, and my lord may say for probably good reason, is what is my position where Parliament has passed a piece of legislation which is in perfect harmony, but only ends up being the harmony being upset by a conflict with a piece of an agreement, and I could take back that word piece, an agreement entered into by the executive. And I felt, and I say this with greatest of respect to the judgment of this court, that it is a difficult question, but I felt the words subject to Section 7 ought to have had some meaning, and not just have no meaning.
Well, we are not going to reargue that this case, Mr. Moran.
No, Millard, I'm sorry, yes, and I... Yes, yes, Millard. My Lord,
anything else that pertains to this case?
Millard, there's just one section.
We can discuss that sometime, maybe in a social setting.
Yes, Millard, and Millard, there on just one further point on building on this question of the security, 25.3, the Act. Sorry, 17.2. May I read, Millard? In any proceedings to which the state is a party, costs adjudged to the state shall not be disallowed or reduced on taxation merely because the proceedings are conducted on behalf of the state. Millard, the purport and intent of an application in pauperis is really to affect an award of cost against the state.
I don't know why you would say that. Is it only against the state now that an order may be made when the state is on the other side? Does it really matter who is on the other side? I didn't think that any of the conditions for being given leave to appeal as a poor person had anything to do with the identity of the respondent. Does it?
Could I rephrase that, Millard? The power then to grant in former pauperis was given to this court to be granted against anybody except the state.
Oh, really? Well, that you would have to show the authority for.
Yes, Millard. Millard, that is...
But Mr. Moran, let's not take too much time on this.
Yes, Millard.
What that section which you just read said,
yes, Millard,
is that the state must not be treated less favorably than anyone else
Good.
when it comes to cost.
Good.
But that doesn't say that it must be treated more favorably, does it?
Well, Millard,
if an order and a person be allowed to appeal as a poor person can be made against other respondents, I can't see why it can't be made as against the state.
Millard, and that is why I suggested earlier on that in an application for ventilation of constitutional rights and fundamental rights provision, if litigant is given the right to appeal as of right to this court, but not the state saddled with the responsibility of meeting an application or meeting a person who has applied in pauperis.
Why not? What do you mean you can't be given that obligation? I don't follow your reasoning, Mr. Mirage. I really don't.
Millard, the reasoning is pinned on the submission, Millard, that an application under Section 8 does not govern an application for fundamental rights provision. That circumscribes the court's jurisdiction. The court's jurisdiction to exercise its discretion in favor of an applicant in pauperis is confined to a criminal and or a civil matter.
It doesn't say that.
Well, Millard, that's my...
It doesn't say that.
That's my interpretation of Section 8, Millard. That's my submission.
Show me what you're interpreting. Read the words.
Subject to Section 7, an appeal shall lie to the Court of Appeal with special leave of the court from any decision of the Court of Appeal from any civil or criminal matter.
Yes. And that means that you can't make an order that a person be allowed to appeal as a poor person against the state.
Well, it's a constitutional matter.
Yeah, all right, I understand what you're saying, Mr. Murray.
Yes, well,
anything else?
If there's nothing I can be of assistance, those are my submissions, my lord. And may I say that I rely on the Attorney General's submission on the question of the merit of the application, my lord.
Yes, okay. Thank you, Mr. Murray.
Thank you very much, my lord.
Yes, Mr. Danville.
May it please your honors, I have laid over the essence of my submissions some time ago, and I will be placing heavy reliance on them. Your honors, I would like to seek your honors' leave to correct certain errors that were in my written submissions, and I beg your honors' apologies with respect to those errors. Your honors, may I respectfully ask your honors to look at page 2. The last paragraph, the proceedings which form, just the S ought to be deleted there, please. And then the penultimate line begins with the word instituted. It should read intituled. Intituled. And your honors, in the very last page of the submission, I referred to the case of Naidiki and others against the Attorney General of Trinidad and Tobago, and the citation there, I'm asking please that 4 LRC be changed to 2 LRC, and the page number should be 659. 659.
Could you repeat that for me?
Oh, I'm sorry.
Naidiki.
Yes, please. On the last page, please, Mr. President. Yes, please. It's 2005 2 LRC. 2 LRC, page 659. What is before the court, your honors, is an application for special leave against the decision of the Court of Appeal of Guyana dated 8th of December 2005, dismissing the appeal of the applicant against the decision of the Court of Appeal of Guyana dated 8th of December 2005. Your Honor, there is an issue as to when the decision of the Court of Appeal was handed down, and my learned friend is contending that it was handed down in February.
Well, depends what you mean by handing down.
Well, the decision, as far as I'm aware, and we can only be guided by the record, the decision is dated December, the 8th of December.
No, I don't think that he's disputing that. I think that he says merely that the written reasons were not given until February, which I imagine you do not dispute either.
Well, I am not sure that my recollection is that the decision was actually, the written decision was actually handed down on the 8th of December.
Oh, well.
But perhaps that can be clarified at a later stage.
I would be surprised if it were not.
Yes, Your Honors, I'm sorry. It is dated the 8th of December. It is dated, the judgment of I Chang, dated 8th of December 2005.
It was read out in court, was it?
I did not appear. Yes, it was read out. Yes.
Well, perhaps we can ask Mr. Gibson, do you accept that?
No, Your Honor, it was on the 6th of February. I think I have a document here.
It appears that a certified copy was issued
Yes, sir.
on the 6th of February. But that was not the date when it was...
Given on the 8th.
But the written decision was apparently handed down on the 8th of December.
Yeah, that's the record of the court, and that's my recollection.
The oral decision was given on the 8th of December.
No, but it is being said that it was the written decision was handed down on the 8th of December. This, the written decision bears that date.
Perhaps my learned friend may have gotten possession of it on the date that he is contending, but it was available for circulation on the 8th of December. And I made a special inquiry to that effect.
Well, were you, Mr. Gibson, were you present when the decision was given?
I was present.
And what happened?
An oral judgment was given by Mr. Chan. And on the 16th of February, the decision was sent
Can't be on the 16th, surely. There's something here which says that...
apparently, it was done after more than signed on the 8th.
But Mr. Gibson, this is very surprising how what they took the bench and just gave an oral decision after reserving judgment.
After reserving judgment was seen at 6 months.
I find that very unusual. I don't know whether that would happen. This isn't the normal practice to do that.
I don't want to say anything. I don't like charging people not present. It took maybe 15 telephone conversations to get that decision out.
Very uncharacteristic.
Anyway.
Be that as it may, Your Honors, the second named respondent opposes this application on the following grounds. One, that the relief claimed in A above is misconceived and wrong in law, and that the contemplated appeal has no likelihood of success, and therefore special leave to appeal as a poor person, or leave to appeal at all, ought not to be granted. I will first, with your kind permissions, Your Honor, deal with ground one. Section 6D of the Caribbean Court of Justice Act provides, and we have gone through that elaborately. Your Honor, it is my respectful submission that the proceedings which are before Your Honors, rather the proceedings commenced by my learned friend in the High Court of Guyana and the matters raised in the Court of Appeal are squarely captured by the category of cases provided for by Section 6D. And I quoted the relevant, that his appeal, the appeal record that are before Your Honors, indicate that they are entitled in the matter of an application by Brent Griffith in terms of Article 142 and 144 of the Constitution. And in fact, my learned friend claims the contravention of several articles of that very Constitution. So it is clear that this is a matter with respect to the alleged breach of constitutional rights, fundamental rights, and are squarely captured by the category of cases contemplated by Section 6.
And I understand Mr. Gibson to have agreed ultimately that it is not a civil case.
Well, I think he said that subsequently. And that brings me, Your Honor, to the next aspect of my argument. And if it is such a case, then there is no requirement of special leave, because he's here for special leave. If it is that it is one of the cases which is caught by Section 6, there is no requirement for special leave. The only leave that is required with respect to this category of cases is that provided for in 10.2 of the rules. And that rule, Your Honor, reads, no notice of appeal, shall be filed unless leave to appeal to the court has been granted by the court below in cases in which there is an appeal as of right to the court. So that, Your Honor, the Rules Committee, and based on Section 3 of the Act, it's part of the law, clearly defined a category of cases. When you are invoking the fundamental rights provision of the Constitution, you require no leave. You have an appeal as of right. The only leave that you require is that which is provided for by the rules of court. And that leave is obtainable at only one forum, and that is the court below.
Can it be dispensed with?
It can be dispensed with in the category of cases that I believe are caught by Section 8. I agree with the contention that Section 8 should read subject to Section 6. Section 8, in my respectful view, is a residuary power, which is an all-embracing power which is reposed in the court to deal with every other case, civil and criminal, that may not have been captured by Section 6. So every other case not captured by Section 6 can be dealt with in respect of an application for special leave on the 8th. However, if with respect to the categories specified in Section 6, then the rule or the rules with respect thereto must be followed. And those rules, the one that is relevant and applicable is the one that requires an applicant who is claiming the breach of a fundamental right to obtain leave from the Guyana Court of Appeal. And that is where my learned friend application should have been made.
What's the purpose of that requirement of leave? If you have an appeal as of right, what is the purpose of applying to the Guyana Court of Appeal?
Your Honor, I had some difficulty in reconciling jurisprudentially the concept where substantive legislation confers a matter that is of right, and then what ordinarily would be regarded as a subsidiary legislation circumscribing that right. But by Section 3 of the Act, these two pieces of document are given equal legislative status. So there is not anymore a collision, as I thought, with one.
There is no collision.
One says
right.
Yes, and then one seems to restrict that right.
Well, it doesn't, not in exact terms. I mean, they appear to be in conflict. You have to construe them, don't you?
I withdraw the word in conflict, but one attaches a conditionality to the exercise of the right that the Act gives. The Act gives you an appeal as of right, and then the rule tells you if you choose to exercise that right, there are certain conditionalities which you must comply with. One of them is that you must seek leave of the court from which the appeal emanates.
But isn't that in respect of procedural matters, how much time you have for putting up security and so on?
It may, in instances, deal with cases that contemplate security, but I don't think it is to be read as confined to those situations.
The leave that is required where you have an appealism right is in order to ensure that the appeal is conducted in a reasonably expeditious and orderly way, and in a way which will facilitate the hearing of the appeal by the higher court. So that the right to appeal cannot be a right at large, which is absolute and unqualified. It has to be exercised in a certain way and subject to certain conditions, and including the possible requirement of providing security for cause.
Well, in this case, my learned friend came as a poor person, which is a different issue we will deal with. So the issue of cost, I don't think was intended to arise in this type of situation. But then, Your Honor, there was the other point which I think we have cleared up, that the date when the act, or rather the date when this court became part of, I think we cleared that up, because it was contended by my learned friend that there was a different date, but it came into force. And it is important in respect...
If it does want a point, sorry to interrupt.
Yes, sorry.
But this again has not been the subject of any query. But if in fact the act hadn't come into force until the 1st of January 2006, then we wouldn't have had any jurisdiction to entertain this appeal at all, would we?
That was the point that I would have made if my learned friend incorrect.
I take it you agree that that given that the decision of the Court of Appeal was given after the act came into force, that the appellant does enjoy the right of appeal conferred by the act.
Yes.
Do you agree with that?
Yes, please. So that I am saying that having regard to the fact, in concluding this point, because he's coming here for special leave, having not gone to the Court of Appeal, and I am respectfully submitting that his failure to do so is fatal. There must be a reason why the court, the rules, provide for an application to be made to the Guyana court. I don't think that provision was put there superfluously. And my learned friend has not advanced any reason, apart from the fact that he was not aware of the existence of this court as Guyana's final Court of Appeal. He has not advanced any reason as to why the Guyana Court of Appeal has been bypassed, why the rules have not been complied with.
Which rules?
The rules of the CCJ.
But were there rules in the Guyana jurisdiction telling him how to come?
I will answer that question two ways, Your Honor. One, he never made the application. So whether there were rules or not...
But how could you make an application if there are no rules?
Well, neither can you make an application, Your Honor, if you don't even know that the court exists.
Well,
his position is that... So, but, Your Honor, the application could have been made orally. The application could have been made the very day that the Court of Appeal handed down the decision. Since there is no set of rules which govern the mode of the application, the oral application could not have been deemed improper. Then he could have gone by way of a motion, which is an originating process applicable and used by the Court of Appeal.
What would be the effect if the Court of Appeal had given oral leave to appeal? At the end, when the decision was given, and they requested leave,
yes.
They said leave granted.
Yes. Well, then the learned friend application would be an application. in my respectful view, you would have still had to come to this court as a poor person for special leave.
No, but what would have been the conditionalities?
Yeah.
How would the progress of the appeal
Proceeded.
be controlled and supervised by the court, by the registrar, for example? What directions would she have as to how this appeal was to progress?
But Your Honor is asking me a question there to speculate how the registrar of the court in Guyana would process an application.
No, I'm not talking about the registrar in Guyana.
The registrar.
I'm talking about this registrar.
Well, I suppose that the court in its order, the one that my learned friend has, and which I suppose is before this court, would read at the last order that the court would have made would be an order granting leave to appeal to the Caribbean Court of Justice.
What would that?
That, I suppose, would have had to have been communicated or transmitted to this honorable court, and the system, the procedure would have been activated.
Mr. Daniels, you are representing the Attorney General.
Yes.
No. I do not think that it would be a satisfactory state of affairs for an application for leave to appeal to this court to be made orally. I think that at least it should be in some form, some written form, and that the terms of the order sought the supplementary provisions of the order should be indicated in the application, and the notice should be given by the application, by the notice of it to the other side, to yourself in this case, and the first respondent. And the court should then deal with it on that basis.
I am not at all, Your Honor, and if I created that impression, I apologize most profusely. I am not saying that a recommended way, having regard to the absence of any procedure in Guyana.
There's, again, a representative of the Attorney General. Do you not think it's an unsatisfactory state of affairs that there should be no rules providing for these applications in Guyana?
It certainly is. It certainly is. But, and I will...
Rule-making authority.
It falls under the jurisdiction of the Attorney General, the Minister of Legal Affairs. I don't know who is the particular office holder.
The Chancellor.
The Chancellor.
The Chancellor is the head of
the Chancellor then.
But don't you not think that it's that the Attorney General has some responsibility in the matter in terms of
I concede that most readily, Your Honor.
Yes. In terms of bringing about
he is Minister of Justice and Legal Affairs.
The making of these rules.
The whole administration of the process that brings appeal to this court comes under his direct authority and jurisdiction. He had to pass the order to bring the action to force.
Perhaps this case, if it does nothing else, will highlight the need for rules to govern applications to the Court of Appeal of Guyana for leave to appeal to this court.
Your Honor, you can rest assured that I'll communicate your concerns and the very important points that you have raised with respect to the non-existence of procedures in Guyana.
And I hope that by now, not only the whole of the legal profession, but the country as a whole is aware of its final Court of Appeal.
I share Your Honor's optimism, whether they are actually aware, I'm not sure.
Because I tell you, quite frankly, we were a little concerned by the fact that the jurisdiction which is available to the citizens of Guyana and to the government of Guyana had not been utilized at all for so many months after it had become available.
It was because of a lack of awareness. And Her Honor, Madam Justice Bernard will tell you that Guyana is a very litigious society, and you'll have to beg them to stop coming when the avalanche of litigation starts.
Now that I say that, I think I have to take that back.
I thought that, it was difficult to believe that any court in the world, far less in the Caribbean, operated so infallibly that there was no wish by any of those who appeared as litigants before it to appeal its decisions. And I thought the Court of Appeal of Guyana must be unique.
That's an ideal that I share most profoundly, Your Honor, but it is an ideal.
Okay.
But Mr. Nanwal,
yes, please,
you agree that the Attorney General has some responsibility for putting these rules in place. Do you think it's proper for you to take that point in this case? The point which you are taking about lack of rules, or the point you are taking in the face of the absence of rules?
That's why I'm proceeding now to Round 2, Your Honor, which deals with the merit. And that's the one that...
But I don't know that, I find yes, that even in the absence of rules, I suppose, one, I don't know that dissatisfied party would be totally without recourse. I would have thought, as you were suggesting earlier, that the Court of Appeal, even in the absence of rules, might have been prepared to entertain, and one would hope that there would be, entertain an application by way of motion or however else applications are normally made to the court for leave.
If I may respectfully...
Guidance are provided with regard to procedure by our rules and by the Act itself. They're not totally, the Court of Appeal would not be totally without guidance as to the manner in which the matter should be dealt with.
I agree most fully, Your Honor. And
I wouldn't like to, speaking for myself, I wouldn't like to give the impression that I accept that leave cannot be obtained from the Guyana Court of Appeal in the absence of rules. I certainly I'm not prepared to accept that as present advised.
Your Honor, I don't think also, whilst I agree with Your Honor completely, I don't believe that the Guyana Court of Appeal consider itself in any way stultified or circumscribed by the lack of rules, because as Your Honors would have heard, an application was made only the 9th for leave to come to this court, and it was determined, unfortunately, against the applicant. But it was so that in the absence of rules, that has not been a hurdle.
Was it an application for special leave to appeal, or also an application for leave to appeal as a poor person? I
did not appear in that case. Mr. Hughes had appeared. It was a criminal cause. I remember that. It was denied. No, the judge is inquiring whether it was a special leave or just leave to appeal.
Leave to appeal as a poor person.
Leave to appeal as a poor person, I understand.
Well, I don't think that the Court of Appeal has the jurisdiction to grant leave in criminal matters. I think it's only in civil matters under Section 7. Surely that only applies to civil cases. But I also insist, as we are talking generally, I would also emphasize now that through to the profession, through you all here, that when an application is made for leave to appeal, whether it is to this court or to the Court of Appeal, the first responsibility on the applicant is to provide not grounds of appeal, but grounds on which the application should be granted. And I think we had a little difficulty we've had in getting this across to the applicants in the two cases that have reached us so far, of which this is one, where the emphasis was on the grounds of appeal. I'm not saying that it isn't necessary to include those as well, so that we know that there is a bona fide appeal and what the grounds of it are. But in addition to that, what we are concerned with, especially when there is an application for special leave, but in any of the cases covered by Section 6, 7, and 8, we want to know what is the head under which you are coming for leave, for special leave, and why you say you are within the provisions of one or other of those sections.
Yes, sir.
Yes, well, perhaps we can allow you to return to your argument.
Most grateful, Your Honor. Your Honor, the second ground upon which I respectfully contend that the application should be refused is that there is no likelihood that the appeal shall succeed. And I have cited in support of that contention the case of Farrington against the Queen, 1996, 48 WIR, page 16, where the Privy Council said, in a case where an appeal lies as of right, it would be inappropriate for the Judicial Committee to grant special leave to appeal as a poor person where it is plain beyond rational argument that the appeal is doomed to fail. So even in cases where you have an appeal as of right, as the applicant has in this case, that does not release him from the onus of establishing, as every application for leave is required to do, that the appeal that you're seeking to secure leave for has some likelihood of success.
But I thought that what that case decided was that even though your appeal was of right, you could not achieve the status of an appellant as a poor person without showing some merit.
Well, that's exactly what I'm saying.
But that doesn't mean to say that you are deprived of your right of appeal.
No, I'm not saying that. I am saying that you.
But in our case,
yes,
there are really two applications.
Right.
There is an application for special leave to appeal.
Yes.
And then there is another application, special leave to appeal as a poor person. Those are two separate applications.
Yes, please, Your Honor. And I am respectfully submitting that in both of those instances, the applicant must discharge the burden of establishing to the court before which he is applying for leave that the appeal that he intends to file has a likelihood of success.
Well, what the case you quoted seems to me to be authority for one of those, but not the other. It is an authority which relates to the question of appealing as a poor person, but it doesn't say that you can't appeal unless you show merit.
Perhaps the other case may convince Your Honor that I rely on. It is Quillen and others against Harney, Westwood, and Regel, number 158 WIR, page 143. In dealing with an application for an extension of time within which to appeal, which the Court of Appeal of Eastern Caribbean States treated as an application for leave to appeal, so there was no issue of poor person here. The Court held that the exercise of its discretion, in the exercise of its discretion, it must, inter alia, consider the chances of the appeal succeeding if the application is granted. The head note reads thus: if prima facie the proposed appeal appears hopeless, the application should be refused, even though there may have been substantial delay in bringing the application. There's some words missing here. It should have been substantial reason for the delay in bringing the application. But the point is, Your Honor, that irrespective of whether you're coming as a poor person, the burden remains on every applicant who seeks leave to satisfy the court that he or she has an appeal that has some merit.
But I suppose you would make the submission that the half was your if in order to grant this special leave or to grant him the facility of appealing, it is necessary to exempt him from complying with some aspect of the rules or of the act, and then we ought not to grant that concession in a case in which the prospects of success appear to be so small.
I could not have said it with greater clarity, Your Honor. That is exactly...
I'm not accepting your
No, but I wish to adopt what Your Honor suggested most respectfully, and that captures in essence. Because remember, it is the duty of every court not to act in vain. And it makes no sense extending all type of facilities with respect to an appeal that is destined to fail. And that is the position I respectfully submit obtains in this case. Your Honor, my learned friend is going, please, in dealing with this submission, Your Honor, I will seek Your Honor's leave to go a little, I will have to, inescapably go into the merits or some aspect of it to deal with the submissions raised by my learned friend. My learned friend is contending that the second name respondent authority, that is the Guyana Revenue Authority, forms part of the public service. And the applicant, Mr. Brent Griffith, is a public officer within the meaning of the Constitution. And I have set out what the Constitution provisions are and how those terms have been defined. And it is clear, Your Honor, that it speaks of something else, a different category of persons, other than Mr. Brent Griffith. I respectfully submit that the plain language of the provisions does not broker any room for ambiguity. And, Your Honor, to deal with the character of the authority, the Guyana Revenue Authority, I recited the long title of the Act, and if I may read it for emphasis. An act to establish and define the functions of a revenue authority. To define the functions of the governing board of the authority. So now there is a governing board that presumably will take charge of the affairs of this authority. To transfer from the government, they are now transferring from the government to the authority the functions and powers of the Inland Revenue Department and the Customs Department. Your Honor, this is a complete transferal of what used to be functions performed by a governmental department, and they are taking it now and putting it into a newly created statutory body corporate. A body corporate that has an existence of its own and that is imbued with functional independence.
Yeah, but in so doing, is that act in some way changing the composition of the public service as set out or as defined in the Constitution, Article 232?
That is an issue, Your Honor, that is presently engaging the attention of the Guyana Court of Appeal.
And the second question, if so, are the procedures employed consistent with those required for such a change in the Constitution?
Well, as I said, both of Your Honor's queries will soon be addressed. In fact, arguments are ongoing, and I suppose Your Honors will have the opportunity to hear them in due course, because I think either side will appeal. Because, but Your Honor, at the end, what in relation to this case, such an attack on a statute cannot be done in a collateral or tangential manner. There is nothing before this court that questions the constitutionality of the Revenue Authority Act. So we have to presume, for the purpose at least of this case, that it is constitutional and proper. And the Act provides, and Parliament expresses the intention in the long title of what it intended to achieve: to transfer from the government to the authority the assets used by the department and the liabilities to which they were subject. So there is a complete removal from the government function, from the functions of the government, and they are residing it into this authority. And, Your Honor, I quoted the judgment of Justice Carl Singh, as he then was, when he was called upon to interpret the meaning of, rather the legal character of the Act, and in the very case that is currently under review. And, Your Honor, I've quoted from what Justice Carl Singh has said. And I have also cited a case from India that speaks to the character of the type of body that resembles the Guyana Revenue Authority. And then I quoted from the General Clauses Act that defines and explains what position in law a body corporate enjoys. And it explains clearly, and if I may go directly to the point that I would like to emphasize, it is in relation to section 31. It's at page 9 of my submissions, please, Your Honor. I'm sorry if I didn't. Page 9 of my submissions. Where any written law contains words establishing or providing for the establishment of a body corporate, the words shall, unless the context otherwise requires, and of course the Guyana Revenue Authority is a body corporate, vest in that body, when it established perpetual succession, the power to sue in its corporate name, the power to enter into contracts in its corporate name, and to do so as regards third party. The body shall be deemed to have the same power to make contracts as an individual, so that when the Guyana Revenue Authority hires an employee, it is exercising the power stipulated in the General Clauses Act, because it is a statutory body, and the law tells you that when I exercise this power, I am regarded as an individual is. So that if I hire someone contractually, I can dismiss them pursuant to that contract.
That was done in this case. There was a...
Well, that is the other thing that I was going to, because it was said from here that there is no provision which governs the employment of employees, or rather the terms of the employment. And if Your Honors, if I may respectfully ask that you look at Justice Chang's judgment, the Court of Appeals judgment, at page 2, he speaks of the employee's code of conduct. And if Your Honors were to look at the reasons why this gentleman was dismissed, it is stated there. Those medical certificates were not accepted apparently on the ground that they were not submitted within 4 days of the absence, in contravention of Rule 40. So there is a set of rules, independent and apart from Section 6.
Where do those rules come from? What are these rules? Well, have you got a copy of them?
I am sorry, I don't have a copy of those rules here with me. I don't have a copy of those, but I can undertake to get them to you.
How are they relevant
within.
in this case? I mean, I appreciate that the judge did refer to them.
No, Mr. Griffith was dismissed because he contravened one of those rules, so it's very relevant.
But are those rules part of his terms and conditions?
They would have been made part of his terms and you see. No, they were. You see, Your Honor, when these persons were transferred from the public service, my learned friend is correct when he says that all their emoluments and so on went with them. In other words, they could not have been given a status less than they enjoyed when they were public servants. Whatever benefits they enjoyed as public servants, they were transferred. But that does not, but when they commenced employment with the Guyana Revenue Authority, they commenced an employment contractually. Of course, they had certain rights that were coming with them in terms of their emoluments and remunerative package. But even if Mr. Griffith had remained in the Guyana Public Service, he was not undismissible. Had he breached one of the rules of the Guyana Public Service, he would have been dismissed. And if the proper tribunal dismissed him, if the Public Service Commission dismissed him, then he would not have been entitled.
But was he given a hearing before being dismissed?
Well, Your Honor, that brings me to another point. You see, Mr. Gibson is submitting. He has come on. I have no difficulty. From the outset, I have no difficulty with conceding that this gentleman may not have been given a fair hearing. I have no difficulty in conceding that his employee, he may have been dismissed wrongfully. I am not conceding, but I am saying that those are issues that...
You say you had no difficulty conceding.
No. Well, I withdraw the dismissal part of it, but with respect to the natural justice part of it. But, Your Honor, where his remedy lies is by an ordinary writ for unlawful dismissal. You see, the article that the learned friend is relying upon with respect to natural justice in the Constitution is an article that guarantees a hearing before a court or tribunal that is set up to determine the final existence of people's rights. By no stretch of imagination can that tribunal be likened to the Revenue Authority. The tribunal that is contemplated by Article 1448, and it is that article that my learned friend is predicating his case, 1448. The type of tribunal that is contemplated by that article can never be a tribunal like the Guyana Revenue Authority.
Is it a tribunal at all?
No, that's what I'm saying. The whole argument is so misconceived. It was overwhelmingly misconceived. It is as if you are going, you have been dismissed from, it's hard to give an example. Because what 144.8 guarantees you is a right to an impartial trial, that type of scenario. It's just like a property argument which I will come to. That is why I'm saying that the complete proceedings.
The matter of interest, the Revenue Authority is a public authority.
Yes, it is a public authority.
And therefore it would be amenable to a prerogative writ.
That's correct. I have no difficulty in conceding that. He can go tomorrow and quash the dismissal.
Writs are popular in Guyana.
Very popular.
Yeah.
The Honorable Madam Justice Bernard wrote extensively on the history of the writ, their utility, and many other aspects regarding their procedures. They are very popular in Guyana. Popularized by Mr. Gibson himself. Except that this time he has used it wrongfully. He did not use it when he should have used it.
But then coming back to your argument, you said even if he were a public officer, held to have been regarded as a public officer,
yes, Your Honor,
he would be subject to dismissal.
He would have been subject to, then that brings me to the other point.
Then there is also this. I'm sure within the public service there are certain rules which govern the types of offence which attracts dismissal. So it could very well be, would you say that absence from duty on sick leave without proper notification, would that have been an offense that would have attracted dismissal?
No, I am not saying, Your Honor, that he was a public officer.
No, I'm saying, just saying on
Okay.
assuming, we're not saying
Okay.
that he is in these circumstances.
Because he was not. Your Honor is asking me whether that would warrant dismissal. I would not be able to answer that, Your Honor. I would not be able to answer that. But
I was just thinking that dismissal seemed to have been a very extreme.
It may have been. It may have been. That is why it could have been reviewed.
I keep asking, what is this? What are these rules of conduct? Where are they from? Where do you get them from? Is there any place where you can find them somewhere?
They must have been laid over.
Suppose that they would be available at the Guyana Revenue Authority.
But it must have been part of the appeal because the judge would hardly have referred to it.
Yes, it must have been part of the record. In fact, I suppose, and I'm merely speculating here, that the letter which was given to him would have identified the breach. One have to presume that, having regard to all the circumstances, that the man would have been told why he was fired.
But your case is that, be that as it may, the procedure was wrong procedure.
Precisely, because and I think, Your Honor, if I may. Your Honor, at this juncture it may be appropriate for me to refer to mirror box. In this case, Your Honor, mirror box, it's 2005 4 LRC. In this case, a High Court judge of Bermuda.
Belize.
Sorry, I'm sorry.
And Guyanese too.
Oh, he was Guyanese? They should have removed him. The High Court judge was removed and a tribunal. Sorry, there were complaints made against him. And a tribunal was established to investigate. The Governor General exercises powers under the Constitution and appointed a tribunal to investigate the conduct of the judge. And the tribunal recommended his dismissal, and he was subsequently dismissed. He challenged claiming the very provision that Mr. Gibson is relying on, 1448. And the Court of, I think it was the Privy Council, said that that is not the type of tribunal that the Constitution contemplated. And this is where this is actually an inquiry of some type of judicial nature. And the reason why they held so was it did not determine the final rights of the particular individual, because he could have challenged, as he did, the findings of that tribunal.
Simple matter of employer and employee.
That is my.
What is this about?
That is my contention. No, but because Mr. Gibson did it. That is his submission. His motion is intituled an application for redress under 144.8. That's why I'm saying, Your Honor, the whole proceedings, they have no hope of success. And Your Honor, query is absolutely in order.
But is that denial of natural justice, is that a contravention? Is that capable of being a contravention of a constitutional right independently of that section?
Well, if my learned friend could have identified any other section, any other rights of his, enumerated from 138 to 151, which captures the of the fundamental rights in the Guyana Constitution, then one could have said yes. But there's none. There is no constitutional right that has been infringed. The Revenue Authority may have acted contrary to the rules of natural justice when they dismissed it, but that is not the basis to invoke the Constitution when the Constitution contains no right that you can claim was infracted as a result of your denial of natural justice. So that takes you back to the common law position of unlawful dismissal. And that is where he should have gone, and that is where the High Court judge told him he should have gone, and that is where the Court of Appeal told him he should have gone.
May also come back to the question of certiorari and quashing the decision.
Precisely.
You know, fine on the dock labor board and cases of this sort going back now about 40 years in England, where there was a successful challenge of administrative decisions by public authorities involving in some cases the dismissal of employees. Those cases established that there was a right on the dismissed employee to have the dismissal quashed, and with a consequential right to receive his salary.
Precise. Your Honor, I concede that that is a remedy that is available, and in fact, I will argue that that is one that he should pursue. But certainly, his invocation of the Constitution is wholly unwarranted, unmeritorious, and misconceived. And if I may read expressly what 144.8 says. Any court or other tribunal prescribed by law for determination of the existence or extent of any civil right or obligation shall be established by law and shall be independent and impartial, and where proceedings for such determination are instituted by any person before such court or tribunal, the case shall be given a fair hearing without reasonable time. Within reasonable time. You have to have...
You can move on.
Okay, very well. Thank you very much, Ron. Now, and that brings me to the other point, the other rule, the other provision of the Constitution that Mr. Gibson is invoking, and it is 142. Now, again, 142 deals completely with a different factual matrix. It deals where a government arbitrarily acquires a person's property, presumably for a public purpose, and enjoins the government to pay just compensation, provided that there is a law that permits the compulsory acquisition of that property. It has nothing to do with the unquantifiable salary that a person may be entitled to. Suppose Mr. Griffith died the next day. What realm of speculation are we going to engage in? You are suing for pension that you don't know whether you will even live to enjoy. That is the realm of speculation that Mr. Gibson is asking this court to embark upon. So 144.2, the framers of the Constitution could never have contemplated that when they were crafting that section, providing for the situation where compensation is to be given, where a person's property is acquired compulsorily, the framers of the Constitution could have never contemplated that salary and benefits and so on would have come under that section.
142 deals with a taking by the state.
By the state, by an agency of the state. So that even if I am conceding, Your Honor, if I am to concede that the revenue authority is, well, it is an agency of state. If the revenue authority, for example, seized Mr. Gibson, I suppose his vehicle, then that's a different thing. But not if I dismiss you under a contract.
We don't know what the terms of the contract are anyway.
But a private contract, clearly, that could not fall into the category of case.
I mean, it may be that under the contract, if you are dismissed for certain misconduct or...
Well, Your Honor, perhaps Naidiki, the case of Naidiki, will assist me in demonstrating to Your Honor that in Naidiki, Your Honor, there was an African-Nigerian doctor who was working in Trinidad, and he had applied for work permits repeatedly, and for a period of time they were granted. And then suddenly Apparently he was participating in he was a pastor and doing some things that were contrary to the work permit conditions. And the work permit was not renewed. And he filed an application. And he invoked the very section 142, claiming that same type of property. And in the Constitution of Trinidad. And the Privy Council held that it had no applicability. The Privy Council reasoned it this way, Your Honor. The unlawful, they captured the argument first. And one moment, please, Your Honor. The Proposition 3 presents Mr. Knox with substantially greater difficulties. He seeks, and that's the proposition, to convince the court that the deprivation, or rather the refusal of the work permit, interfered with the gentleman's property as guaranteed by the Constitution. And the Privy Council reasoned it this way. He seeks to support it by reference to three authorities. One, Rees and Crane, and they give the citation, concerned a High Court judge in Trinidad and Tobago unlawfully excluded from the roster of sittings for the following term. The Privy Council dismissed the state's appeal against Trinidad and Tobago Court of Appeals order upholding the judge's constitutional challenge on the ground that his fundamental right to protection of law under 4B of the Constitution had been violated, and the decision to suspend him was contrary to Section 137(1) of the Constitution, which provides about how the judge can be removed from office. They said that the Crane case was completely relevant to the point. As they just cited it to dismiss it. And then they go on to choose cases that were relevant. Dr. Naidiki had no substantive right to be granted a work permit, only the right to have his application fairly decided. They were saying that, look, Mr. Rees was a judge. He had a salary. He had a constitutional office. His position was protected. You could only have removed him under Section 37. So it was wrong for the lawyer, Mr. Knox, to have used that case in support of his argument with respect to a work permit. It was totally irrelevant. They distinguished it. And then they move on to deal with relevant cases. The present case has much closer similarity to the Marks and Minister of Home Affairs, 1984, 35 WIR, page 106, a decision of the Bermudan Court of Appeal quashing a refusal to grant a work permit of a foreign psychiatrist who after 6 years has built up a lucrative practice. It was also similar to an assistant Metropolitan Police Commissioner against Howell, and they gave the citation. And this was where a London cab driver had built up a lucrative practice in the area in which he was driving cabs and so on. And they chose another case again of dock workers. But Your Honor, in all the instances, they held that, look, these people had built up a reasonable practice in whatever, but that did not amount to property. That, the connection between that and your right to be granted a work permit was too remote. And that is the situation here. Office can never be property. Your Honor, and in Alonzo, the last case I would like to refer is Alonzo. And for the simple point that Alonzo was a statutory corporation of similar status of the Guyana Revenue Authority. And Alonzo hired, some persons questioned their dismissal. And they went under the Constitution of Trinidad, claiming constitutional redress, and the court held that even if the body was a public authority, the act of employment and the act of dismissal are not powers of a public nature. It is a power of contract. It is a power of contract. So that if there is a breach of that, then you sue under the contract. In this case, you sue for unlawful dismissal. So you must also look at the particular act that the Revenue Authority was engaged when it dismissed. Is dismissal of a person, an employee of the agency, an act of a public character?
What was the form of action in Alonzo? Was it a constitutional motion or?
One moment, please, Your Honor. 1985, 359. Oh, it's Belize, not Trinidad, I'm sorry. It's Fundamental Rights, Section 13, Constitutional Right. The appeal was dismissed.
Yeah, but what did they come by?
They come by constitutional motion. So these are the authorities that I'm relying on, Your Honor. I cited them for Your Honors. And I have the additional authorities that Justice, and of course Perch, very important case. Perch, Your Honor, when my friend was saying that he was going into uncharted sea, he was not, because Perch has dealt with this issue already. The Postal Service of Trinidad and Tobago was created for similar reasons that the Guyana Revenue Authority was created. And there's a reason why these authorities are created. It is a recommendation. Well, I don't know what was inspired it in Trinidad, but it was an IMF recommendation in Guyana that certain functions be delinked from the government and be performed by state agencies. And that is important because Perch, the Privy Council mentioned it in Perch. In Perch, Your Honor, they had a similar, they were transferred from the Postal Service. If they wanted to continue working, they could have remained in the public service. They could have been transferred, or they could have accepted a package which was offered to them. In this case, they accepted the package and they retired. But they were saying that their acceptance was an imposition. And it took away from them their constitutional rights and so on. And it has the identical Section 6 that my learned friend has invoked and has emphasized so greatly.
You're in the, I would like to say fortunate or unfortunate position of having two of the judges who sat in that case sitting here now.
Oh, I am so sorry. I am so sorry. So that
Let that tell you.
No, I'm so sorry. So that, Your Honor, Your Honors have let me know at this late hour, belabor a point that I'm sure. So Your Honors, those are the authorities that clearly demonstrate that the application filed by my learned friend is invocation of constitutional remedies are all wrong and misconceived. He first of all must identify the rights, the constitutional right that is infringed. And then you go to the remedy. But he can't cross the first hurdle. He has not been able to cross the first hurdle. Which right has been infringed? It can be the right under 144.8 because that speaks to a court, a tribunal, not the nature and character of the Revenue Authority. And it cannot be 142 that deals with compulsory acquisition of property. So that his application for constitutional redress
made reference to 149B, I think, or something.
Well, yes, Your Honor, he made reference to that here today, but that is nowhere in the submission. And it is not in the rubric. Every public sector shall enjoy an absolute and unenforceable right to any pension or gratuity granted to him, or her under the provision of any law or collective agreement of any kind whatsoever. This has no bearing to what we are talking about. Nobody denying any public sector employee any pension which was granted to him under the provision of any law.
He's saying it's an absolute and enforceable right. Yeah.
Well, that is the other thing. This looks declaratory. I'm not sure this is a right that is justiciable, that is enforceable. It seems to be declaratory because it's not phrased the way the other articles are phrased. And this was only added to the Constitution in 2003. That is why I was a little surprised by it. This is a very recent addition to the Constitution.
The claim is not for pension.
No, the claim is not. It's for compensation. And it's for compensation of a breach of a constitutional right. The right has not been established. And if the right has not been established, how can the breach be established? Or how can compensation flow for that breach? So there are three things. You have to get the constitutional right first. You have to establish that there was a breach of the right. And then you show that you're entitled to some kind of compensation as a result of the breach. And Your Honor's observation is quite appropriate that this is not the type of proceedings that one should employ with respect to not constitutional breaches, but in respect of matters where evidence has to be taken. And Your Honor identified the case from the Privy Council where certain sentiments were expressed and a regret was expressed actually about the manner in which the applicant in that case approached the court, because you deprive the court. These motions are done by way of affidavits. There is no trial really. It's only if there is some inconsistency, then one has the right to cross-examine. I don't think evidence was taken in this case, so we don't know why evidence was taken. Okay. So the judge would have found that there was no dismissal, which is even worse. No, I didn't even know that evidence was taken. I'm just being... But the point is, Your Honor, these are not cases where when you have contesting facts that can be resolved properly and fully and properly ventilated by way of emotion. And that's what the Privy Council said, that I think was Jaru, Dr. Ramsahoy's case. Not very pleased with the ruling of the Privy Council, but I spoke to him about that. No, he lost. He wanted another forum to go to appeal, but there is none. But, Your Honor, if there is no other queries, I think I have kept you on.
Are you relying on Jaru?
Yes, I'm relying on Jaru, and I credit the court for bringing it to my attention. And there is another one of Ramanand, I think, shortly after Jaru, that deals with the same point. I think Jaru was followed and approved in that case. Mr. Ramsahoy, Dr. Ramsahoy again, with Anand Ramlogan, I think his name is, argued that case also. So if there is no further query, Your Honor.
Thank you, Mr. Nanla.
Thank you very much.
Mr. Gibson, do you wish to say anything in way of reply? Briefly.
Thank you, Your Honor. Your Honors, I just want to say one or two small points. I filed an affidavit to this court on the 2nd of February 2006, in which it was pointed out in that affidavit that up to the date of filing, the written decision of the Court of Appeal was not available. I do not like to say anything about judges, but I understand, and I was present when the registrar of the Court of Appeal nearly lost his job, because he told the judge you didn't sign the decision, so they couldn't be sent out.
So it was available on the day it was delivered?
No, it wasn't available. It was I said it was typed short sometime afterwards, and it wasn't signed by the judge. until I went and demanded a copy. Regrettable, but that's what it turned out to be. Under the fundamental rights and...
What are you saying? When did this happen?
This happened sometime around the 12th or 14th of February of this year.
No, but on the...
I really don't like to get into these arguments with judges.
On the 8th of December, was the judgment pronounced?
The judge pronounced the judgment in court. He read it out, and the judge in court retired.
He read it out?
I read something from you or something. But I'll tell you one thing. The other judges just...
They concurred.
Well, actually they concurred, even though they don't say it. No, what I say is this. You don't have to say you concur.
He wrote the judgment of the court.
Even judgment of the court.
Oh, that's it.
Well, I'm not following.
What is that? They read the judgment. They read the judgment.
Read it?
Read the judgment.
Yeah.
The judgment as such was not printed. The point was printed sometime afterwards.
Yeah.
Sometime it was printed. And it was not until I personally went to the Court of Appeal and demanded a copy that I got a copy. And the registrar and the judge didn't sign it. I had it typed, but you didn't sign it.
It was handed down. The important thing is it was handed down.
It was handed down. Nobody crying. It's on the 8th of
December.
Yeah. May it please Your Honours, it was just brought to my attention under the Fundamental Rights and Practice and Procedure Act of Guyana that constitutional matters of this nature, are called civil proceedings and dealt with under Fundamental Rights Practice and Procedure Act number 13 of 1988. Act. It's among those that you have, Your Honor.
What does it say?
An application to the High Court for redress under Article 152 of the Constitution may be made either by way of a reading motion or by way of summons.
Which section is this?
Section 3.
Oh.
And 2. Subject to the provisions of subsection 1, the Rules Committee will make rules with respect to the practice and procedure of the High Court in relation to the powers and so on, but that procedure was not made.
Yeah, but how does that...
No, what I'm just saying is dealt with under the general civil procedure of the court.
In an originating motion.
Originating motion and originating summons, which are matters of civil procedure.
Mr. Gibson.
Sir.
You had earlier conceded that this was not a civil case within the meaning of Section
Yes, sir.
8 of the Act. Are you changing your position?
Yes, Your Honor. It's just been brought to my attention that the Act exists, which says what it is.
Withdraw that?
May I politely say so?
And on what will you argue that?
I'm now saying it's a civil proceeding. It's dealt with as a civil proceeding.
Said that it's a civil proceeding.
The Fundamental Rights Practice and Procedure Act.
Yes, will you read the relevant?
An application to the High Court for redress under Article 150 of the Constitution may be made either by way of a relating motion or by way of a writ of summons. And this is a procedure... Because this is a procedure used to introduce civil proceedings in my country.
This says an application under Article 153.
153, of which this is one.
I don't know. You were relying on 144 or something like that.
No, 144 is a part of 153. 153 is a procedural section which says without prejudice to what is lawfully available, you may apply to the High Court for redress.
I don't follow your reasoning. You are saying that because the same form of originating process is used, that this makes that a constitutional case, a civil case.
A civil proceeding.
No, I am saying with respect to Your Honor, that this is the way civil proceedings are begun in Guyana.
Well, that may be so. But it doesn't mean to say that it can't be used to begin constitutional proceedings as well, without converting constitutional proceedings into civil.
No. See, I am putting it this way, Your Honor, put it this way. Without prejudice to what is lawfully available. Something else may be lawfully available. Without prejudice to that. Any proceeding...
Without prejudice to what else is available. It has to do with the nature of proceedings brought to complain and to seek redress for the contravention of constitutional rights.
Of which this is a fundamental right.
And that is not in dispute.
No.
The question is whether such proceedings, which are described in paragraph D of section 6, are civil proceedings. That is the question.
Yes, Your Honor. One second. If I might put it this way, Your Honor,
Yeah.
it is dealt with. Let me frame it in better language. We are not saying it is per se a civil proceeding, but it is dealt with under the civil proceeding rules.
But that doesn't make it a civil proceeding.
No, it would not.
Yeah.
Logically.
That's it.
Thank you, sir.
Yes, thank you. Well, we thank you for your assistance, and we reserve our decision, and we'll give it on a date to be announced.
All right.